ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ? ಹಲೋ ಹಲೋ ಸರ್, ವಾಯ್ಸ್ ಮತ್ತೆ ವಿಡಿಯೋ ಕ್ಲಿಯರ್ ಇದೆಯಾ?
ಮ್ಯಾಮ್ CH-2 ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸ್ತಿದ್ಯಾ?
ಹಲೋ, ಕೇಳಿಸ್ತಿದೆ ಮೇಡಮ್.
ಸೀರಿಯಲ್ ನಂಬರ್ 23 ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀರಲ್ಲ?
ಸೀರಿಯಲ್ ನಂಬರ್ 1 ಇಂದ ಶುರು ಆಗುತ್ತೆ ಮೇಡಮ್.
ಓಕೆ, ಥ್ಯಾಂಕ್ ಯು.
Who has died? What is it matter about? Matrimonial case, which year? 70. You want to argue? Other side also wants to argue. We will list it on your IA for early hearing day after. You have filed an application for early hearing, right? Yes. No adjournment. 10:30 we don't grant adjournment. This we have been telling for past 4 years, but not a single day passes when we are not required to say no. Don't, I mean, go wherever you want to go, go. It is listed before us. We will deal with it even in your absence, because we have taken oath to do justice according to law. Go wherever you want. Yes. What is recalling, Mr.?
Appealing for the respondent in this matter, my lord.
Delay is there. Delay. All right, Mr. Restored. Delay in filing.
Can I request one matter, my lord? This matter has been, they've been taking adjournments. I'm not objecting on recalling. Again, the matter will, they'll not argue the matter. It is dismissed for non-arguing.
Dismissed.
For not arguing the matter, my lord. It is, matter keeps coming up. Either they take adjournment or they
All right.
don't appear. Let it come in the same stage. For let them argue the matter, my lord.
But nobody's there even today. We can pass it over at the most. All right. Pass over.
Please, my lord.
Last. This has been issued? No, no, no. This objections. Date of death to 2 weeks time granted to comply with office objections, failing which application shall stand dismissed without reference to bench. Second time, 2 weeks further time, failing which appeal shall dismissed for respondent number 6. So what, it has become infructuous. If, this is furnishing of PF to respondent number 6 for second time. So we have granted you 2 weeks time to pay process fee. Don't pay, then it will be dismissed for respondent number 6. Don't continue.
File a memo, mister. Why are you making that submission before the court? If you want to retire, please retire. There is a registry there down. Please file a memo there.
Huh? So who is responding to this? See, we are held up in a matter which is not of substance, right? You are not prepared to comply with office objection and you are telling all sorts of things. Huh?
Deputy Director of Public
Deputy Director, why are you not paying process fee? We have granted 2 weeks time. I mean, I don't understand where is the scope for argument in this. But you pay process fee. In addition, let a copy. In addition, say let a copy of memo of appeal along with annexures be supplied to learn it. You have to pay process fee. Other office of 2 weeks time we have granted. Tell him that we have granted 2 weeks time. What office objection? Huh? What dismissal? It's a petition under Article 227, right? That's the objection. What do you say? The single judges exercise powers under Article 226. This is the argument. What do you say with regard to writ of mandamus? That could be issued only in exercise of powers under Article 226. And when an order is both under Article 226 and 227, it will be read as like, huh? No, this mandamus is issued. Right? No, but do you mean to say this? He has also not understanding. Do you mean to say that while exercising power under Article 227, the court cannot issue any further direction? Huh? That, what is this?
My last original application which was filed before. I was not the party. Except page number 76.
No, sir. Presently, we are only confined to determining whether it's an order under Article 226 or 226 and 227 both. Simple. Why? What order of this thing? What was challenged?
by the civil court.
IA by the civil court.
Yes.
Then
The order part. I was not a party to that proceedings account.
this is so what?
If I was not party to the proceeding.
Yeah.
First time I was made party in the legal proceedings. When I was made party in the proceedings, first time ever, the original power which has been exercised by the. And the sufficient in that manner, since that particular power, the order has been passed, tracing to the Article 226, the writ if I were the party before the executive court, when that internal application was filed, then it is a power which has been exercised by the executive court, assailed under Article 226. Not so. First time I was made party in the restitution proceedings, I was arraigned as respecting therefore my suggestion is that the original jurisdiction which has been exercised, the article 226, not the 227. The suggestion is that the original judgment will not come in the way and with the language in.
No, but this may be a 227. Page 14, 27.
6, 226 and 227.
Petition is 226 and 227. Page 27. Hey, Mr. Where the facts justify filing a petition? What is the law? What law? The law is page 70. No. You don't. If you don't know, say no. We will tell you. The legal position is where the facts justify a filing a petition under Article 226 and 227. Then from the nature, from the order itself, the court has to decipher whether the power under Article 226 and or 227 has been exercised. And if it's under Article 226 and 227 both, then an appeal would lie. This is what Supreme Court has said in number of, we can give you 15 judgments starting from 1986, right? So this is a petition under Article 226, 227. The single judge has issued the writ of mandamus. Not a party.
It's not a party to the suit, that's what he said.
So he had to pay. How are you agreed by this? You have deposited 22,52,000. You have deposited.
There was an order by the executive.
We will have to hear on that. Let a learned counsel for the respondent submits that office objection has been complied with. Let the appeal be listed for orders on admission as well as on the question of maintainability of next week. What week commencing 7th November 2020.
5
weeks preliminary. Want to withdraw? That's filed a memo seeking leave of this court to withdraw the appeal. The memo is taken on record in the result appeal is dismissed. Accordingly, the appeal is dismissed as withdrawn. Two preliminary. Weeks preliminary. Weeks preliminary. Weeks preliminary. Weeks preliminary. 2 weeks preliminary. Oh, what is it? Okay, yes, passport. Well, passport. 2 weeks password, 2 weeks preemptive, which has filed a memo seeking leave of the withdraw the appeal. Memo dismissed as
Okay, government delegate.
2 weeks.
16.
Pass one.
17, I'm appearing for the appellant in this matter, my lords.
Peremptory. 2 weeks peremptory.
No, I'm filing a memo for withdrawal, my lords. Just now, parties have informed me that they're withdrawing the case. 17, my lords. I'm sorry.
Filed memo seeking leave. Withdraw. Dismiss the withdraw. Yes. All right, 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks.
Appearing for the appellant, my lord. Kindly pray time, my lord.
Next. 2 weeks.
Much obliged.
My lords, I'm for the appellant. 2 weeks time may be granted.
2 weeks. You grant strike. Tell them. Take time how much you want from me. 2 weeks. 2 weeks. 2 weeks.
I appear for the appellant, my lords. Take a short accommodation.
31. 31, 2 weeks.
It has arise for the same order. Much obliged.
32, 2 weeks. 2 weeks. 2 weeks. 2 weeks. 2 weeks. 39. So 2017 appeal. When will you argue? Other side is not even present. We will have to proceed.
Parties are directed. These are directed.
Parties are directed. When present, and when the other side, we will pass on. PIA.
Holding that not further expiry is required. That is challenged to the situation in the model.
Let him come.
It's another writ appeal challenging the correct. There is another writ petition or writ appeal filed challenging the order passed by the Chief Secretary.
Let him come. Password next.
Appeal arises from the petition. Appeal arises from the interim order granted in the EIL.
Itself has been nothing survived. Yeah, you want to withdraw? 41. What is this? What, ma'am? What do you want to do? All right. What order? Learned counsel for the appellant has filed a memo stating that the appellant, which is a limited liability partnership, is under a process of liquidation. And one Kundi Setti Kumar Dushyanta is appointed as liquidator in view of aforesaid submission issue notice to the liquidator. The details of on the address, the details of which have been furnished in the memo.
Party to A. Putra, D. Ravi.
So, what is the income of the applicant? Income of the applicant? What happens as soon as the matrimonial case is filed? The parties start practicing the path of renunciation. So, left everything, surviving on thin air. Assets and liabilities affidavit. Left. What is the judgment? Rajni, what? In view of law laid down by Supreme Court in so honorable Supreme Court in so and so. Give the citation. It's there. So and so learned counsel for the parties pray for and are granted 2 weeks time to enable them to file an affidavit, file their respective affidavits with regard to assets and liabilities. What your appeal has been dismissed? Preemptory order.
He's not present.
44. Yes.
So.
Recall.
Presented.
Which one there?
No, he's in the second matter.
Second. Paso. He is not even present. That shows may not be interested also. Dismiss it. Doesn't come. What is whose appeal? MFA. Appeal only for grant of permanent. 2 lakh. What? What I mean, 2 lakh has been granted. What else do you want? You want 2 lakhs from her. Huh? You want 2 lakhs from your wife. Huh? What is? This is your appeal is only against grant of permanent alimony, right? 2 lakhs has been granted. What else? I mean, 2 lakhs is a petty sum. Nothing. Nobody can survive. I mean, even if she keeps it in a fixed deposit, she can't.
This installment you want. This first year 2019.
2019. So what have you done? Except 3 years have passed. You want an installment. So did you deposit any installment to show your bona fides? Driver doesn't mean that. Please appreciate. Driver doesn't mean that he is not bound by law. He is also bound by law. But still you won't pay, right? No,
This is disposed of in the month of October 2019. Even if you would have deposited 5,000 per month, by now 2 lakhs would have been. The bill is filed in the month of November 2021. For the last 1 year, have you paid anything? Not ready to pay. You should have shown your bona fides. 1 lakh. Not there. Asking to deposit 1 lakh. You deposit 1 lakh.
then go to jail. What else? What else can be done? 21, this appeal has been filed. You are not doing anything. Not even paid, say 10, 20,000 rupees also. No, not 20. It's 50,000 on or before 2 weeks. 50,000. 50. If this is not, so then let him go. Then don't argue. We don't have sympathy for such a person who is not willing to comply. There's nothing wrong with this
Decree
appeal.
of 2019, 2 lakhs has been awarded.
You go to jail.
We are in the year 2022. You don't want, you want to deposit 50,000. Nothing can be done, mister, if that is the position.
Dismiss your appeal. There's nothing wrong with this. 2 lakhs is nothing. You're a driver earning, and this is a permanent element. Ask me. No, this is not. I mean, if you can pay, then only you seek time. Otherwise, there's no point. We will dismiss this appeal today itself. You go to. Yes. 3 weeks. This appeal has been filed.
Just to be.
Delay. Hold on, IA1 of 2021. An application seeking for the reasons assigned to be 102 days control IA allowed. This appeal under section 19 within bracket 1 of the Family Courts Act has been filed against judgment and decree dated 24th October 2019 passed by the Family Court, by which the decree for dissolution of marriage has been granted on the ground of cruelty. In addition, the Family Court has awarded a permanent alimony of rupees 2 lakh to respondent. Learned counsel for the appellant submits that this appeal paragraph. Learned counsel for the appellant submits that this appeal has been filed only against the impugned judgment and decree insofar as it directs payment of permanent alimony to the tune of rupees 2 lakhs. It is further submitted that appellant is an auto driver and has no means to pay the amount in one installment at a time. He further submits that the appellant is ready and willing to deposit the amount as may be directed by this court. Paragraph in view of the court's submission, it is directed that appellant shall pay a sum of rupees and shall deposit a sum of rupees 50,000 within a period of 3 weeks from today. No, nothing. There's no bargaining. 3 weeks from today, to which execution of the impugned decree insofar as it directs recovery of the amount of permanent alimony from the appellant shall remain stated. 50,000 before the registry.
Admission, number 46, BS setting. Irregular, incertificate.
Huh? Oh. Yes. You know, that's why you are appearing, right? Adjournment is being sought that you knew and know in advance. That's why without file, you are appearing and smiling. No. What is the appeal about? Yes. No means tell us. Why? No means we thought that you are ready. What is the appeal about? What has the learned single judge done? Tell us. Don't appear, Mr. without fight. This basic you should know. What is this? This is not a park, right? This is High Court. Don't appear before this court like this. And it's not necessary that we merely because she's saying that this court will grant adjournment. What makes you so confident? You don't know anything about the case. What is the appeal about? Tell us. What has the learned single judge done? Just like you come to Rome about here, don't know anything. How many years? 1 year is good enough. At least to know what the learned single judge has done and why have you filed an appeal. If 1 year, if you don't know this, then how bright your future is, we can anticipate. In another 9 years, you may cross and come here and sit. Because 10 years, you will be eligible to become a judge of this court. Don't take it lightly, at least not in this courtroom. You go anywhere, do whatever, but we don't like this. Your smile told us that you don't have any idea and you know that it is being adjourned. She has assured you, don't worry, I will not permit you the trouble of this thing. This what? She told that I will seek an adjournment. Fortunately, sorry, we feel sorry about you. No, we feel sorry about you. Your future, what will happen? In 1 year, if you don't know, why have you filed an appeal? What would you do next? Let the God be with you always. That's all we can pray. And bright future to you. What else? Disgusting. You don't even know what is the order. Opponent counsel for respondent prays for adjournment on the ground that the arguing counsel is unwell. Just after 2 weeks.
My lords, appearing for the appellant, my lords. My lords, there's a slight personal difficulty. We pray that a week's accommodation may be granted.
Appeal about.
You appear for the appellant.
Yes, my lords. My lords, a week's time may be accommodated for making submissions. Maybe listen next week.
What ground you are seeking adjournment?
My lords, the senior has a slight personal difficulty, my lords. We just wish that
You don't have any personal difficulty, right? That's why you are appearing. So what is the appeal about? What has the learned single judge done?
my lords, this is a writ appeal that is arising out of a 2017 decision, my lords. But my lords, with respect to the submissions, I request that the matter may be listed next week.
Why have you filed an appeal?
My lords, because there are distinctions between the decision that were relied on and what our position is. Therefore, but to substantiate those grounds, my lords, we request that the matter be adjourned to next week.
Praise for adjournment on the ground. Yes. We have heard it at length. We
My
know
lords,
why you
there
are
is-
seeking an adjournment, but unfortunately, there is no change of roster after 1 week also. It will come up before us only. We have understood why you are seeking adjournment. Unfortunate mistake. Senate counsel for the appellate prays for adjournment. on the ground that the what arguing counsel is not well.
Yes, my lords, he has a slight personal difficulty, my lords.
Personal difficulty and being not well are two different things. We are asking you, is he not well?
Yes, my lords.
Then you are saying that when I asked you, you said that he has personal inconvenience. Means what? Personal inconvenience means several things, and being not well is another thing. So at least
Apologies,
you
my
should
lords.
be clear- no, you should be clear. If you don't know any, you have a right to ignorance that we concede. But at least you should know why you are seeking an adjournment. You don't even know that why is he not well or what that's what we are asking. So that we write in the order sheet, we have adjourned the case. But we are only asking, what is it?
My
Not
lords,
well.
the arguing counsel is unwell, my lords. I apologize, but we request that it be adjourned, my lords.
See, really, what they will do? On the ground that arguing counsel is unwell. List after 1 week. No further adjournment shall be granted, Mr.
Much
Yeah,
obliged, my lords.
Right. We are telling you. No further adjournment shall be granted. You don't appear on the next date. Right? Huh? Don't appear. We will go through the records and pass an order. You don't appear on the next date of hearing to seek adjournment. Clear? Oh, unable to hear? Huh?
My lords, I couldn't hear the last part.
That's what we told you that don't appear on the next date of hearing.
No, my lords, we shall appear,
Seek
my
an
lords, we shall
adjournment.
make
Don't appear.
submissions. I apologize, my lords. It's just
We will go through the record and pass an order. Right?
apologies, my lords,
And
but we shall appear on the next
assign
date, my lords,
reasons.
and make our
We
submissions.
will assign reasons also for passing an order, right? You may succeed, you may not, but please do not appear for seeking an adjournment.
We
on
will
the
not,
next-
my lords. We shall make our submissions. Humbly obliged.
Yes. Next. Huh? Item of the name of Mr. Yes.
Number 48. Interim.
Amendment in the cost title, non-amendment. Don't want to do it. Well, week's time is granted to comply with office objections, failing which appeal shall stand dismissed. You take 2 weeks. 2 weeks time is granted to comply with objections, failing which appeal shall stand dismissed without reference to bench. Then IA 1 of 2019 for the reasons assigned in the application, the requirement of production of annexures is dispensed with. In the result, IA 1 of 2019 is allowed. What additional? Weather is changing, Mr. Every you see. Just now, somebody told us whether that shows who is not well. Oh, acha. Yes. When do you want? Request for adjournment on the ground that arguing counsel is unwell. List after 2 weeks. Interim order shall continue till next date of hearing.
Number 50. Already the paper.
For the appellant, my lord, I have complied with the office objections. I have complied.
Learned senior counsel for the appellant submits that the office objection have been complied with.
And your lordship made a request, this may be heard, my lord.
We want to hear, but he is saying something.
Yes, some difficulty, it may be.
That's what he's saying. He's telling us about the difficulty only. You hear him. Can you hear what is he saying?
No, I have not been able to hear.
speak into the mic so that
We
senior.
have engaged senior counsel. Very good. Thank you. We can have it next week. We are ready.
Yes, Mr. Rao. Next week is.
Next week is your lordship puja. The
Oh, you are the only counsel. Yes, really.
no, my lord, I am not saying it will be difficult.
No. Yes, right. You are right. Absolutely right. So when you tell us there are.
ಇದು ಮಂಡೇ ಬರುತ್ತಲ್ಲ, that is my lord,
Monday.
not next
7th
Monday, the
7th November.
yeah, 7th November or 31st, whichever your lordship convenient to the court, my lord.
No, everything is convenient to us, Mr. Rao. So our job is to sit here at 10:30 and to be here till 4:30.
My lord,
So,
we have been assigned some job, we have to do it, my lord.
yes. So what 31st you want?
Yes, as your lordship pleases.
31st October?
Yes.
On the ground.
My lord, your lordship also has told him that he should not retire any more persons before that last time.
31st,
31st
31st October 2020. Yes. What is it? What's the P? Marriage, desertion. It's appeal against dissolution of marriage or desertion. What is the cruelty? Both. Marriage has been dissolved under on the ground of desertion. Both. Dismissed. Desertion granted. Appeal is admitted for hearing. Issue notice. No. It's already there. Appeal is admitted for hearing. Office is directed. Notice on behalf of respondent is accepted by learned counsel who has entered appearance on appeal. Office is directed to secure the record of the family court. Let objections, if any, to IA1 of 2020 be filed within a period of 2 weeks. Meanwhile, operation in effect of impugned judgment and decree insofar as it pertains to dissolution of marriage shall remain in state till next day of hearing. Admitted for hearing, same order. Admitted for hearing. Issue notice on IA2 of 21. Record meanwhile directed. After admission, record then heard on IA2 of 21. Then meanwhile operation in effect of judgment so far as it pertains to marriage shall remain in order. Yes.
54, the police ready here.
He is admitted for hearing, issue notice, record.
You have admitted the appeal. We have admitted the appeal.
Twice we have told you, but you are preoccupied with your submissions. We are not opponents, right? I mean, you can't expect the court to admit it because how can, I mean, if we say something, we have to oppose you necessarily, right? This is the perception. We are telling you we have admitted, but it's not registering. Perhaps you feel that, no, I have to argue, fight it out. Then only the court will. Otherwise, if I don't argue, they will dismiss my appeal. We are not sitting here to dismiss your case. We are here to decide it in accordance with law. Notice has to be issued. There is nothing to argue on admission. Yeah. Admitted for hearing record. Dismissed. Admitted for hearing record. Meanwhile, what state? What is there to say? No. Only a decree can be stayed, Mr. No observation can be stayed. What is the observation? Your suit has been dismissed. There is nothing. There is no execution proceeding. There can't be any stay. Read order 41 rule 5. What is order 41 rule? What can be stayed? Is there an executable decree? We don't know. The application in any case under order 41 rule 5 does not lie. There is no executable degree. No executable degree. Correct or not? You can execute this decree.
Pending in appeal. And it stays in my suit. I have filed a suit for declaration.
It says suit of the plaintiff is dismissed. So, and this application is under order 41 rule 5. Please enlighten us. Give him order 41 rule 5. No, please read. Please read. No. We would learn something from this if you read. Please. How it can be stated? I mean, we thought it's here as a noonday, but you are still arguing. So we want to know how can we stay? What can we stay? What can be stayed under order 41 rule 5? It's here. Admitted for hearing, learned counsel for the appellant seeks leave of the court to withdraw IA 1 of 2022. Accordingly, same is dismissed as records. Records admitted. No, not there. We will reject it. Heard on IA number so and so. Heard on IA number 1 of 2022. We did not want it to say that it is misconceived. That's why we thought, but you still want. Very good. We did not want that Mr. Sudhakar Pai files an application without reading a provision. So we didn't want to, but you are inviting it. Heard on IA number 1 of 2022, an application under order 41 rule 5 of the Code of Civil Procedure seeking to stay the finding recorded by the first principal judge family court DK Bangalore in OS number 8 bar 2019. Order 41 rule 5. Full stop. We have heard learned counsel of the appellant at length. Had filed a suit seeking the relief of permanent mandatory injunction, directing the defendant to vacate the scheduled premises within the time fixed by the court. Of the aforesaid suit has been dismissed by judgment and decree dated 26th August 2022 by the family court. Full stop. Under order 41 rule 5 of the Code of Civil Procedure, comma, an order of stay of the execution can be made, full stop. In our considered opinion, comma, the judgment and decree dated 26th August 2022 is not an executable decree as the suit filed by the plaintiff has been dismissed. Therefore, the application filed by the appellant under order 41 rule 5 of the Code of Civil Procedure is misconceived. Accordingly, the same is dismissed. Record. Action. First. This first matter. What that? First matter.
Name is not shown in the cost list. Name is not shown in the cost list. He was settling for R1 and R is not shown. That's why the
Office is directed to reflect the name of Mr. Srinidhi V. Correspondence.
First our matters, serial number 1. Utility entry.
None for the appellant. None for the appellant, Mr. Reddy, senior counsel for the respondent. None for the appellant, even when the matter is called in second round. This application has been filed seeking recalling of the order dated 14/3/2022 passed by this court, which appeal preferred by the appellant was dismissed for want of prosecution. Paragraph. It appears that the appellant is not interested even in prosecuting the application seeking recall of the order dated 14/3/2022. Accordingly, the application is dismissed for want of prosecution. Reduce next level. Yes, yes, down delay. Because
it is not enclosed. Segment is not enclosed. It will not be in a position to discuss.
see, fifth time they are just they know everything. Nothing is not appearing. They know that if they appear, they will decide. None for the each time preemptive. None for the appellant even when the matter is called in second round. Each time is granted to comply with office objections, failing which appeal shall stand. Same order. See,
35 years.
35 years. So none for the appellant even when the matter is called in second round. This intra court appeal has been filed against an order dated 19th of July 2021 passed by learned single judge, by which the writ petition preferred by the petition preferred by respondents number 3, 4 and 5. 3 to 5 has been allowed, and the order and the orders dated 30th/11/2018 and 27/8/2015 passed by the deputy commissioner and assistant commissioner under the provisions of that PTCL Act, right? Whole thing have been quashed. Paragraph. Facts giving rise to filing of this appeal. Briefly stated are that land measuring 4 acres in survey number 245 was granted to one Nigamma, namely the mother of late Manchamma, by an order dated 28/7/1947. Full stop. The original grantee, namely Ningampa, by a registered sale deed dated 6/10/1947, 1969 sold the land measuring 2 acres and 9 guntas in favor of father of respondents 3 to 5. Full stop. The legal heir of the grantee, namely Manchamma, filed an application under section 4 and 5, under section 5 of the Act after 35 years, that is in the year 2013. Full stop. The Assistant Commissioner, by an order dated 27/8/2015, allowed the aforesaid application. The said order was affirmed in appeal by the Deputy Commissioner by an order dated 30th/11/2018. Full stop. Paragraph. The respondents 3 to 5 challenge the aforesaid orders in a writ petition, which has been allowed by learned single judge by an order dated 19th of July 2021. In the aforesaid factual background, this appeal has been filed. We have considered, we have perused the record, that paragraph, and then in the instant case, admittedly, the paragraph again. In the instant case, admittedly, the land was alienated on 6/10/1969, and after an inordinate delay of 35 years, an application under section 5 of the Act was filed seeking resumption. Full stop. Thus, there is an inordinate delay in filing an application for resumption for which no explanation has been offered. Full stop. The learned single judge therefore has rightly held that the appellant was not entitled to seek resumption of the land. Full stop. Aforementioned do not find any merit. Feels dismissed. These are present. But you are appearing. But it's no longer a taboo, right? In good old times it was, but now younger generation, No, but younger generation feels, no, wait, why we are telling you from our experience in the court itself. Younger generation, they don't longer, they come and say simply take the check and go away from here itself. Mutual. Yes. So.
Hearing applications are there.
So which day you will argue, madam? Tell us. This for early hearing. Huh? This is. We have filed 3 applications for expediting the hearing. So We'll hear you, madam. Whatever you tell a date, madam, then tell a date, whatever is convenient. We'll fix a date of hearing. Tell us. First week of November. Ah. Yes. Ah. Ah. No, we believe that, we believe that advocates are good clients. They are good clients, right? All right. So which, so you tell us, madam.
We are not hearing the matter on appeal. We are only fixing a date for hearing. Yes.
So what date? First week of November, madam?
No, she said last week. She said
Last week.
Third week.
21st November.
21st November.
For hearing. Mark this as. But on IN number 1 of 27, 1 of 19, and 2 of 19. No, in compliance of the order, previous order, whatever is order, the parties are present. Then heard on these IS, 3 IS, taking into account the fact that the FTP is pending before this court since 2017, the interlocutory applications are allowed. Let the appeal be listed for final hearing on 21st November 2022. Monday, madam. Monday. Twenty-fifth is Friday. Yes, madam. 25th.
28th.
20. Monday, 28th. It's a list on
28th.
Whatever.
There is a marriage in the family. 28th.
28th November. What, Mr. No, that's fine. What is it about? Right. All right. This intra-court appeal has been filed against an order dated. What is the order? Dated 25/7/2017, passed by learned single judge. Paragraph: learned counsel for the parties fairly submit that in view of judgment and judgment 29 September 2022, passed by this court in WP number 25124/2016, nothing survives for adjudication in this appeal. Accordingly, same is disposed of. I give it to him. He write the name of the parties also.
Yes, Gupta. PG Ravi.
What interesting. What to discuss?
Who has filed IA 1 of 22? By the
What is the non-compliance of the order? Order. What is the non-compliance of the order? You have not paid maintenance. Why? There is an order, right? What happened? Not for the appellant, even when the matter is called in second round. What's your name? Learned counsel for respondent. Wait. Learned counsel for respondent submits that against the order dated 6/4/2022 passed by a bench of this court, the respondent has filed a special leave petition before Honorable the Supreme Court, which is yet to be heard. In view of opposite submission, hearing is deferred. List after 2 weeks.
Number 44. Shrikant.
Huh? We thought that you are not interested. Huh? This time? So this is for recalling, right?
for recalling 2 days to comply.
Acha, after recalling 2 days time. Huh? After recall you want. Height of Mr. Srikanth, casualness, right? Then we don't need this, your apology and sorry. You should go ahead with this. Not you, but this thing we say, see the cause, the 7th time, 8th time, non-compliance is all. I mean, we wonder what do you tell your clients. As an advocate, I always found it difficult to face my clients. They were telling me that our case is not being heard. I wonder what skills you people have got and how do you manage that. I mean, we are ready to hear and adjournments are taught. Really, hats off to your skills. I mean, you means everybody, not you in person. Heard on IA. What do you tell that the court is against you? That's what that if I will get the case listed, it will be dismissed. Then you will be responsible. Don't tell me. Like this you tell, no? No. Whatever. Generally we are saying, not this case. This is over. What do you tell when the client says that my case is not being taken up? What do you tell? That no, judge is he doesn't understand anything. You will lose the case. I will get it listed, but you will do. Not for me, any court, right? What do you say? This is so casual, Mr. Court. Third on IA 1 of 2022 and appearing in second round for reasons assigned in the application, which is duly supported by an affidavit, the order dated 20th/9/2022 is recalled in the result WA 510/2022. Week's time is granted to comply with office objections, failing which appeal shall stand dismissed without reference to bench.
For final disposal.
What kind? By final disposal? Who is appearing? Who appears?
Complete. Pass. He comes. Pass over.
Pass over then, madam. Please wait for a while.
Finally, number 59. You can.
Ready? Record. What is this review?
Bringing the property of the petitioner for sale. That came to be, there it came to be held.
Whatever record is available, no, Mr. Huh?
Events, based on events. Analysis. Analysis.
Wait. Wait. Relax. 1 minute. Let us go through the facts. 25388 says notice. Seven sale proclamation.
Stands disposed. What will stands disposed of?
It appeal.
Right, review arises from the order of the written.
So it's only review we are doing. So we are dealing with only review, right? Not writ appeal. Writ appeal, this review arises out of an order passed in writ appeal. Give us 2 minutes. Receiver issued sale proclamation, recovery. Yes. Eight. $159. $159. $159. Yes. And let it be the notice of the High Court. Counsel appearing for the also submitted. Yes, let this fact also be examined with the High Court. The special decision are worked out. The diligence of the High Court after reproducing the order has observed that the appropriate order proves that the animal the observed. So where are you reading? Let this fact be examined, especially petitions are disposed of. But no, you are reading something else, so we thought. Page 150, 30th April, right? You have an extra set, give it to him. 59. Yes. Yes. Ah, 1 crore. So let this fact. Thereafter. Next page, it was that order is 163. This proclamation is a connected way underneath in a paper. Paper book. If you could tell us what grounds you are seeking review, so then you can then seeking review of the order dated. To 11/2011, right? 2011. 639 of 2009. 2009. That is no circular in the written appeal. That I have heard of in the paper book. Written appeal. Yes, which page of paper book you told? So you briefly tell us what are the grounds on which you are seeking review?
Not considered to be notice, and not cutting the notice on the petition. That is the requirement of section 168. 168. Petitioner matter. Then the next round is matter. They got the property for sale. And that was on 3/4/2006. That is the paper in 129. Then we'll add this property, we'll add the base value, we'll add fixed by the authority. On 3/4/2006. Action of conducting. Nobody came. Rupees 75 lakhs. Base price was 75 lakhs. Now when we are reaction, instead of doing that, he sells this property. 65 lakhs, let's get 65 lakhs, 50,000. 65 lakhs, 50,000.
How it was sold? How it was sold? Acha.
Almost like 10 lakhs lesser than the said value. What they are
Also, like they sold it below reserve price, right? That's
below reserve price. Like as per my land, section Milan, sorry, 174 of the land in hand. 25% of the land bid amount has to be deposited. Same day. Section 174 of the land in hand. Like instead of depositing the bid amount of 25%, the both respondents pays the cash of 16,37,500.
what is 25% of 65 lakhs?
Yes, ma'am. That comes to 16 lakhs, 37,500. 25%.
Yes.
Then he paid only cash, he paid only 6 lakhs. 174 mandates in lakhs. It should be on this day, you should deposit 25%. Instead of depositing 25% amount of the bid amount, when he pays cash 6,37,500. So the rest of the amount, 10 lakhs, he issues a check. Check bearing number 29147 for 10 lakhs on that day. And when we issue the check on that day, the authorities don't clear with me. They don't present the check. That the bank account of Alpha is. So, on that day, this bank paid the check for 10 lakhs. He did not come. The check was presented in collusion with the revenue authorities.
5 days, day after. 100 days. It is not even affects in the same. Yes. Like on 25/4/2006, this Milan amount has been in cash. So the 10 lakhs are here. So they are that they Milan. 25% of the amount for Milan compared with the mandate in private. Thereafter, what happened next? The petitioner after the sale proclamation made next year. Discrepancy in area. Discrepancy in the area.
What they did was the property which was not for sale as per the action notification it has been issued.
Basically, procedure irregularities which have not been taken. Yes. Page
18. Page 118.
So, I mean, you are basically saying that the sale suffered from various infirmities and which has not been taken note of by division bench, right? And the division bench has upheld the order passed by single judge upholding the sale, right? So these infirmities have not been taken note of, therefore review, right? Huh?
Yes, ma'am.
So,
This where the extent of the property shown in the sale proclamation.
which are exchange is 119.
Yes.
Ah.
And I want to identify.
Ah.
Very, very important.
Yes. Yes.
This is the measurement. 100/80.
Sides.
Sides showing the measurement.
What is this? 121. What is it? 121. Daily proclamation. 21. Daily proclamation. 124. You should have told us in the beginning itself. Pass over, Mr. Rajgopal. Pass over. Ah. Right, better. Give a synopsis, Mr. What is there? I mean, this what has been simple, right? This what has been held by division bench. And on these grounds, we are seeking review. Simple, right? It shouldn't take more than 10 minutes. You are referring to all this proclamation as if all review. I mean, why these are the findings 1, 2, 3, 4. Just a minute. That's what we want. These are the whatever findings of the division bench in writ appeal. And what are the grounds on which you are seeking? Why that is perverse? What is not taken into account? What is that? That's it. Simple 2-page synopsis you give. End of the matter. He will enlighten us on the scope of review. That correct. That's it. It should not take more than 15 minutes. He will conclude within, Mr. Rajgopal will conclude within 5 minutes. Right? You will conclude within 5 minutes. Huh? Nothing. You have to only argue no ground for review is made out. That's it. What? That's what we told him. You will. That means that there is no case. No case. So we rightly assessed or not that you will tell us about the scope of review. We told you that you will enlighten us about the scope of review. So he may be right in saying that if you keep on arguing, that means you won't have a case. No, that's what we are saying. That he may be right in saying that if you keep on arguing, that means you don't have a case. You have to tell us this is what is the division bench finding and this is what is the review or grounds of review. Not more than 5 minutes. Nothing. What I mean, argue, we really don't understand. This tomorrow. This tomorrow. And what day after?
On.
3 days. Day after tomorrow. Praise for adjournment. No, it's all right. This day after. Day afternoon. Fine. Hey, don't open your cards. Why do you put him on notice? You would not like to put him on notice, right? Beforehand. Huh? Oh, of course. Now what shot? Mr. You are appearing for appellant. Mr. Reddy is seeking adjournment.
I appear for respondents, my lord. Respondents.
What? Twenty-nine. 29th. Mr. Rao, 29th October. Your colleague is praying for adjournment. Not his name is 60.
Lord, I appear for respondents 1 to 3.
Acha, so what I mean, what 31st October, Mr. Praise for adjournment.
No objection.
List on 31st October 2020.
Great.
Oh.
I appear for the appellant, my lord. In this
Speak
case,
English,
my lord.
right?
In this case, my lord, I have, what has happened is 2 workmen, my lord, of the Mysore Lamp Works, the erstwhile Mysore Lamp Works, they were terminated. Raised a dispute, my lord. The labor court held termination is wrongful, but granted them only compensation because in the meanwhile, this MP Mysore Lamp Works went to liquidation. Then, my lord, they filed an appeal. The the learned single judge, my lord, has said, no question of now reinstatement. I'll give you 1.5 lakhs. Of course, 1.5 crores means he would not have come here, my lord.
Yeah. Yes.
1.5 lakhs, my lord. Now,
Yes.
your lordship may recollect, now, my lord, thereafter, in the process, this Mysore Lamp Works, my lord, was revived. Your lordship may kindly see. Your lordship also is a party to an order on which, my lord, which I have produced now, sitting with the Justice Nataraj Rangaswamy, my lord. There is an order which I have now produced. I am only saying, since there is a revival, he is entitled for reinstatement and consequential benefits, my lord. I have produced all those orders, my lord, and all those authorities in respect of these 2 workmen. That is the matter before your lordship.
Yes.
That is the IA. Lord, I have filed an IA2 with those amendment and of the subsequent events and the judgments, my lord, I have produced.
Amendment, what do you say? This is based on subsequent event, right? So have you filed objections to this amendment and all that? All right. So yes, Mr. Rao, please go ahead.
Yes. My lord, your lordship may kindly say, I'll the application. May I read, my lord, the application?
Amendment.
Yes, application for amendment. That gives, my lord, all the facts.
Yes. Additional prayer.
Yes, yes. I have made the additional prayer in view of subsequent developments, my lord. And also that mineral corporation also has to be, because this was merged with the mineral corporation. All those workmen, my lord, were
So notice has been issued of this application for implement to mineral corporation.
my lord, I'm sorry, my lord. I should have known it.
Counsel for respondent says that no notice has been issued. We will have to give it to proposed respondent, right?
Yes, my lord. There is a mineral corporation is represented. I'll give a copy of this notice, my lord.
We will deal with it. Let the thing. So we will say, Mr. Rao, issue notice of this IA, right?
Very well, my lord.
So we are Rao and senior counsel with so and so for the applicant. Shashi Kiran Shetty, senior counsel with so and so for respondent. Issue notice of IA 1 of 21. Proposed issue notice of IA 1 of 21 as well.
IA 1 and IA 2, my lord. IA 1 and IA 2
of 21. 1 of 21 and 2 of 21 to proposed respondent. List immediately as soon as the proposed respondent is served.
Well, my name may be deleted. My SN Murthy Associates. Please be deleted, madam.
Deleted. Office is directed to delete. Yes.
Much.
Number 62.
I appear for the appellant in this matter, my lord. We have engaged senior counsel Mr. Holla in this matter, and he is down with COVID and is quarantined for 2 weeks. The matter may kindly be listed after 2 weeks.
For appearing for the appellant.
Appearing for the appellant, my lords.
Learned counsel for the appellant submits that the arguing counsel is unwell, therefore prays for adjournment just after 2 weeks.
The
appellant's counsel, what has happened is, by our file has been misplaced, my lord. We will try.
All right.
we tried to
Appear for
search it. We tried to search it, my lord. We could not locate it. my lord.
I appear for R1 then.
I request your lordship sometime.
How much time?
2 weeks, my lord. Immediately, because next week anyhow is Deepavali. Yes.
Yes.
Thereafter. Yes.
It came from Paral senior counsel, the appellant.
7th or 8th, your lordship may kindly have it.
It is working, right, Mr. 8th November.
8 now. Yes, ma'am.
Working.
Yes. Restricted.
It's for short accommodation to enable them to address this court. It's on 8th November. 8th November.
Much obliged.
64. The Sampath Chetty.
What did you tell him? He did. That's too much attention we should give. And we don't see a humor on. The only one. No. Yes. Who? What inconvenience, mister? These are all these things after 10 years, I mean, you are seeking adjournment. Don't appear. You are not concerned, don't appear. Don't decide. What? This 2012 appeal, right? 10 years after you. So, this for adjournment just after 2 weeks. Let it be who. Yeah. Not bothered anybody. What can we do? Don't appear like this. Don't like it. Don't this thing assure anyone that I will seek it. You know this court. We are reluctant to grant adjournment. Why should you take upon yourself unnecessary burden? Tell them I can't do anything. And court, if supposing if it takes up, then what will happen to your case? Oh, what? He's not here, right? Why he should suffer that? Why he should wait? I mean, for unnecessary. We have adjourned it by 2 weeks. We have to celebrate the success that you have been able to seek an adjournment in a 10-year-old matter. Be happy. Okay. 9th November. List on 9th November. Praise for adjournment and say list on 9th November. No adjournment. Don't appear, Mr. Don't appear.
65.
Your Lordship, my Lord, Your Lordship's kind permission, my Lord. With Your Lordship's kind permission. Lord, we are ready, but I am informed from the other side. They have engaged Mr. Uday Holla. Lord, he is not well. And we have been trying for last year. I don't know whether they have appeared or not. We are ready, my Lord, but they have only.
Which date? Tell us. Yes, Mr. Which date?
My lord, any date convenient to them, my lord, because we have been.
Huh?
Because he is in part.
No, all right. So when do you want time date? We are asking you for a date. Otherwise, we tell you will say no, inconvenient. That's the problem.
My lord,
That's
in
why-
this, my lord, 1 minute, my lord. In this, both of them engaged senior lawyers. And we were ready, but unfortunately, this time Udayawada sir is not well. So that is why, my lord, let them take any date, my lord. I have no objection.
Yeah. Tell us. 8th November. Ask him.
8th November.
Yes, my lord.
Learned counsel for respondent prays for adjournment on the ground that the arguing counsel is unwell. List on 8th of November 2020.
My lord, let it be on the orders list, my lord, so that it can reach. It's a
No,
board
what
matter.
time? What's the time today? We want to ask. What's the time today? What's the time right now?
Time, my lord, 12:30, my lord.
So it has been called, no?
No, now I understood, my lord, you are asking why asking that. My lord, this time, my lord, today, there were so many process matters. That is why I could able to reach, my lord. Because we tried several benches, my lord, it was not even reached even after 4:30. That is why I requested. Otherwise, I have no grievances with this bench, my lord. Your lordship is very fast, we know.
No, we don't need a certificate. Well, you should know. I have also been a counsel. We know when a matter is listed, what to do. And when the number is not reaching, we mention on that day. We are not this thing. We don't know what will happen on 8th of November.
Yes,
If
my
they
lord.
did
That
not
is,
reach, you mention at 2:30. Do whatever. Even that we are required to tell you what to do. And you
please,
are
my
giving
lord,
a
no.
certificate.
My
This
lord,
bench
this is
is
not a
fast, this is
grievance.
slow.
This is not a grievance, my lord. We
No,
can
please
only
don't.
request
We
like
don't
your
want.
lordship.
No, we do not want to give any special treatment. You are agreeing to an adjournment, it's being adjourned. We don't want any special treatment to be given to any case.
That's correct, my lord. But only thing is, my lord, we being a council, but we have to request your lordship. Otherwise, there is nothing, my lord. And we are not even pricing. We know very well, my lord, your lordship.
Number 66, the A. Nagarajappa, the H.N. Basura, government advocate.
Yes. Huh? Nothing. No coordinated bench. See. This 12-10-21 since 12-10, 1 year settlement. And 2 months not well. 2 months inconvenience. Like this, you go on, right? This 1 year exactly. 12-10-21, you have been making statement, it will be settled. 1 year, if you have not settled, what makes you believe that the client is having, except telling your client that the judges are about to dismiss your case and somehow I am avoiding the bench? What explanation can you give? 8 years, 8 years. 12-10-21, not 22. 1 year ago. Then nobody has asked, Mr. Nobody has asked you that you were granted time for settlement. Why the judge, if the matter is settled, judges are benefited? No. Who will ask them? What is this? Who is asking you? They show us an order. You have learned counsel for the appellant again seeks time for settlement. You have sought time for settlement. 1 year has passed. Have pity on your clients. Have pity. 8 years. And 1 year you have been telling this court, I'm just seeking time like this. He's saying no settlement. What? Why don't you argue? You may succeed also. It says only to report settlement if any. 24(8) also top of the list. No settlement. What he's saying, no settlement. Why? Please argue. No, they are not. No question of settlement. 1 year we are not ready to grant time. That's all. We don't. On 7th, you will say again that it is being settled. Today morning he had called something. We don't want. Tell us a date of your choice. On that date, it will not be adjourned. You find out. So you think about it and tell us. It will not be adjourned on that date. That's we are clearly telling. Despite several opportunities being granted for past about 1 year, appellant, learned counsel for the appellant has not been able to report settlement. Stop. We are not therefore inclined to adjourn the case for reporting any settlement. However, learned counsel for the appellant is for adjournment to enable him to prepare the case and argue the same. It is made clear that no further adjournment shall be granted on any ground, right? Including the ground that you are not well. Understood? Don't engage. Then don't tell us on that day. Today, senior counsel, we will impose cost of ₹50,000. I'm telling you right now. If you make a statement on that day that we have engaged a senior counsel and therefore it should be adjourned, any ground means every ground. Just on 7th of November 2020. You said 7th. He said 7th November. We told him that you choose a date of your choice. He has chosen 7th November. 8th, he will say that it's not convenient. Let him, he has to argue. 2014. Yes. 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 Yes, Mr. Ready? Can. No, that we can't do. You know it. Whom to move, what to do. You know everything. Then again, you will say that this court directed me to make an application. We are afraid nowadays. Like that, in previous case, he was telling court directed me to settle the matter. So you will write to the registrar judicial, court directed me to make an application for leaking of the matter. We are afraid, really, not to say. You are a senior advocate, you know what to do. You also know we can't do this. We don't know. So in you want an adjournment, right? long and short of it, Mr. Naganan. What to do?
Persons who are ready, my lord, compensation has been.
What, the 31st October, Mr. Naganan? 31st October.
Second.
You tell us. That's why we don't propose, never propose a date, because when it's not a single case where we have said and it has not been opposed. 100%, because whatever we say has to be opposed. Has to be opposed. It's like this, that as if we are fighting a battle, we are here to torture you. It's like the approach is like that, Mr. Mental setup is like that. Whatever you just see that. You just see whatever just says, you have a tendency to oppose. It's a mindset, not a thing. We are not enemies, but you perceive. You perceive. Yesterday, we made a counsel to argue. He felt that appeal is being allowed. Eventually, he succeeded. But I mean, this thing is like this, that if we are compelling you to argue, that means, appeal is being allowed. Like this, mindset is like this, to oppose whatever, and be it a date. Like we just said 31st, immediately you said that, no. And it is 100%. I mean, it's not a coincidence. You may not be there, but 100%. Tell us a bit. What is a Saturday, a Friday? Yes, Mr. Nagan. Okay. All right. So what date? Yes. 10. Fourth, yes, fourth. Learned Mr. Basavaraj sir, learned senior counsel for respondent number 11, praise for adjournment. List on what 4th November 2020. Yes. You do it, I mean, it's implicit, right? Whatever it is. Yes. All. Yes. Yes. Oh, shall we place it? All right. 68, right? 68. Mark the presence, Mr. Naveed Ahmed, learned counsel for the applicant. Mr. S.S. Naganan, learned senior counsel with so and so. Learned counsel for respondent. Learned counsel for party jointly submit that the matter was heard before division bench headed by Honorable Mr. Justice B. Veerappa. The aforesaid fact is also reflected from the order sheet dated 21/9/2020. Full stop. In view of aforesaid, let the matter be listed before the bench headed by Honorable Mr. Justice B. Veerappa. Let the appeal be listed for consideration. Registry will list it now. Yes. You're not here. Before that, you are not here, right? No, happened. We don't know what happened. Why you should not be ready, madam? This is 8-year-old appeal. He may go anywhere, like he may go to Hyderabad. That means we are bound to adjourn. I'm telling you, your senior, he feels like he will go anywhere and we will adjourn. Why should we adjourn 8-year-old case? Why it should be adjourned? Why don't you argue the case? What is there? No, ready means the court should take up only when you are ready. But what happens supposing if we refuse to grant an adjournment? What makes you believe, madam, with so much of this thing, conviction and confidence that whatever, whenever you seek adjournment, the court is bound to grant an adjournment? Every case we are seeing, you are seeing yourself sitting in the court. Each and every case. We don't know. Learned counsel for the appellant raised for adjournment on the ground that they are going of this list after 2 weeks.
Number 70, the A. Rajesh. Chetan B. Number 71, Srimati Nandita Haldipur. The Ravi Kumar Enna.
Please wait. Oh, you are there. Passport.
72, the Gopal Singh.
For the appellant, my lord, in this case.
The B.N. Kutumbayya.
72.
Yes, my lord. I am for the appellant in one appeal, my lord. There is a cross appeal also, my lord.
What is it?
It's regarding divorce, my lord. It's a husband's appeal, my lord, from my side.
It has to be regarding divorce. What else?
No,
ultimately
it was
also. It pass over. We will just take it up.
all right, my lord.
33, the K. Jagdish, the Chandraya.
Pass over. Oh, yeah. Yes. Oh, nothing. No adjournment. Good. No. Nice to hear. No adjournment. 25 lakhs.
Only with regard, matter is only with regard to alimony.
Alimony. Yes. Your petition, your wife. So your petition for divorce has been allowed.
He's against alimony.
So you are against alimony. What is the, how much is granted? 1,000 per month. You are willing to pay lump sum amount of 25 lakhs. What do you do? Executive engineer. Loan. Good that you are doing something, otherwise many others they don't do anything and don't have a source of income also. Yes, Mr. What do you say? How long you have been living away? 16 years. No. What's this thing like? Even if we drag it, supposing set aside the degree, supposing set aside the degree, will it be possible for you, both of you to live together? No. Maintenance. So that we can. So he has made an offer of 25 lakhs. If you have to say anything, please tell us. What do you want? What do you say? What is your proposal?
You are residing in that house now?
Oh, house and what else? 50 lakhs. Ah. Working, are you working? What is your qualification? Not working anywhere. Hey, who gives the job to SLC people? That's fine, but what do you say with regard to this offer? Where she will live? 25 lakhs she need to put in a FD, right? She's taking care of a son also, no? Then he will need money. We are not on to the paragraph. We are just trying to discuss, Mr. Court. So like she will have to take care of the son also, right? He is aged about 18 years. 19 years. Then she has to take care of the son also. He will need money for his education now, higher education, whatever he goes to a professional course or whatever. What is he doing? Hey, you are an executive, right? What one paragraph? There is no question. What is your offer? You have heard your wife telling you 50 lakhs and a house to live in. Or you provide a rented accommodation to her. Instead of you provide a rented accommodation, right? Make arrangement for a residence somewhere. This could be an rented accommodation. Right. So where do you stay, Mr. Tumkur? You will get an accommodation for 5,000 rupees. No. You give 8,000, Mr. Difficult to get 10.
5,000, I don't think you will get a house, Mr. No, 25 we are only, we know what is your income. No.
We will see that paragraph also, don't worry. We will see that. Ask him that boy, this person, executive engineer, compliments better. See, Mr. It is better to buy peace, right?
What is your present salary, Mr.?
Come here.
Yes. What is your present salary? 90,000. 2013, your salary was 1,11,000. I'm asking you what is your salary present, not take home. You might be paying so many installments. What is the
day by day it is reducing or what? 2013, 1,11,000. Now In 2022, 90,000. Thereafter, it will be 80,000. After
You are a government servant. And therefore, it is not difficulty for us to get your salary certificate. Then, yes. What is the income? What is the income, Mr. as per the salary certificate?
He's bringing. Just a minute, he's bringing. There, he's bringing. No, that's fine. See, 1,83,473. Obviously, TDS will be deducted. But you understand, right? I mean that she's right in insisting that she should have a. No. Let him find out why is he giving money. Let him find out an accommodation for whatever. He may get it for 2,000 rupees also. What is the 2-bedroom accommodation? Let him get. 2-bedroom accommodation, whatever amount, let it be 1,500 or 2,000 rupees. Why? No, 25 lakhs is on the lower side.
For house, they will get their house. ಆಯ್ತಲ್ಲ, ನೀವು ದುಡ್ಡು ಕೊಡಿ, ಅವರು ಲೀಸಿಗೆ ಅವರೇ ತಗೊಳ್ತಾರೆ. ರೀಸನಬಲ್ ಆಗಿ ದುಡ್ಡು ಕೊಡಿ. ಒಂದು 10 ಲಕ್ಷ ಕೊಡಿ ಅವರಿಗೆ ಲೀಸಿಗೆ, ಅವ್ರು ತಗೊಳ್ತಾರೆ. ಒಂದು 50 ಲಕ್ಷ ಇದು ಪರ್ಮನೆಂಟ್ ಆಲಿಮನಿ, ಒಂದು 10 ಲಕ್ಷ ಕೊಡಿ, ಒಂದು 60 ಲಕ್ಷ ಕೊಡಿ. ಡಿಡಕ್ಟ್ ಯಾತಕ್ರಿ? What reason it has been deducted? It is your savings. Deducted ಅಂತ ಹೇಳಿದ್ರೆ it is your savings. And you have got a wife and son. ಸೆಟಲ್ಮೆಂಟ್ ಆಗ್ತಾ ಇರೋದು. ನೀವು ಯಾವ್ದನ್ನು ಓದೋದು ನಿಮ್ಮ ಹತ್ರ ಸೆಟಲ್ಮೆಂಟ್ ಆಗೋದಿಲ್ಲ ಅಂದ್ರೆ ಆಮೇಲೆ ನಾವು ಓದ್ತೇವೆ. ವಾಂಟ್ ಟು ಸೆಟಲ್, ಯು ಸೆಟಲ್ ಇಟ್. ಅದನ್ನು ಓದಿ ಇದನ್ನು ಓದಿ ಅಂತ ಹೇಳಿ ಸೆಟಲ್ಮೆಂಟ್ ಟೈಮಲ್ಲಿ ಮಾತಾಡಬಾರ್ದು. You are settling it, you settle it. And 1,83,000, you take it at 1,50,000 ತಗೊಳ್ಳಿ. 1,83,000. ಇಲ್ಲ, ಈಗ ಅದಕ್ಕೆ 41 ಲಕ್ಷ ಲೋನ್ ಇದೆ. ಅದಕ್ಕೆ 41 lakhs ಲೋನ್ ಇದೆ. You clear the loan and give. He does not want anything. 41 ಲಕ್ಷ ಲೋನ್ ಇದೆ ಅಲ್ಲ, you clear it. He does not want alimony also. ಕೊಡಿ. You clear the loan and give the house. No alimony, only house, alwa. He is ready for that. 41 ಲಕ್ಷದಲ್ಲಿ ಆಗ್ತದೆ ನಿಮ್ಗೆ. Yeah, very difficult. You said 25. Sir, 25 lakhs you said, and another 5 lakhs for house also you have said. Now you have said the loan is only 41 lakhs. Clear the loan and give the house. He does not want anything else, he says. 30 lakhs, yes. The loan is only 41 lakhs. Another 10 lakhs you have to pay. That's all. 10 or 11 lakhs. You are giving to your wife and son. You are not giving to anybody else. You are providing an accommodation to your wife and son. You are not losing anything. You are providing something. Don't have. Even if she is working, what would be her salary? You say that she is working in a society. She has 10,000 ಸಂಬಳ ಇರಬಹುದು ಹೆಚ್ಚಾದ್ರೆ. Even if it takes, your earning is 1,83,000. ಅದರಲ್ಲಿ 33,000 ಇನ್ಕಮ್ ಟ್ಯಾಕ್ಸ್ ಹೋಯ್ತು ಅಂತ ತಿಳ್ಕೊಳ್ಳಿ. 1,50,000 you are earning. ಅದರಲ್ಲಿ 50,000 ಆದ್ರೂ 41 lakhs you can pay and you can get rid of all problems. 41 lakhs you discharge the loan. ಅದು ನಿಮ್ಗೆ ಉಳಿತದೆ. ಅದರ್ವೈಸ್ ಯು ಹ್ಯಾವ್ ಟು ಗಿವ್ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಕಟ್ಟಬೇಕಾಗ್ತಾ ಇದೆ ನೀವೀಗ. ಆ ಇನ್ಸ್ಟಾಲ್ಮೆಂಟ್ ಕಳಿಯೋದು ಉಳಿತದೆ. ನಿಮ್ಮ ಮಂತ್ಲಿ ಇನ್ಕಮ್ ಜಾಸ್ತಿ ಆಗ್ತದೆ. You cannot be even thought of that. You do not have any other property having regard to your income. This is not a this house. I think it's a ancestral house or self-acquired house. Self-acquired house. In addition to his salary, he should be having some ancestral property also. Whatever it is there. ಆಯ್ತು, ಈಗ ಎಷ್ಟು ಎಕರೆ ಇದೆ ಅಂತ ಬೇಡ, ಅದು 41 ಲಕ್ಷ ಕೊಟ್ಟು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡಿ. ದಟ್ಸ್ ಎ ವೆರಿ ಗುಡ್ ಆಫರ್. ಅಂಡ್ ಯು ಆರ್ ಪ್ರೊವೈಡಿಂಗ್ ಎ ಪರ್ಮನೆಂಟ್ ಸೊಲ್ಯೂಷನ್ ಟು ಯುವರ್ ವೈಫ್ ಅಂಡ್ ಸನ್. ಒಂದು ಅಕೊಮಡೇಷನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಿ. ಕೌನ್ಸಿಲ್, ಟೇಕ್ ಸಮ್ ಇನಿಷಿಯೇಷನ್. You have come up to 30 lakhs. All that is has to pay another 10 lakhs ಅಷ್ಟೇ. Giving up your house ಅಂತ ಹೇಳಿದ್ರೆ you are not giving. Yes. Out of the ಹಾ 30,000 ಅಲ್ಲ, ಅದು 30,000 ಇಲ್ರಿ. ನಿಮ್ಮ ಸಂಬಳ 1,83,000 ಇದೆ. 150. 20% to the wife. What about the son?
Yeah, what major?
What major, Mr. 18 years is still studying, and now expenses will increase after 18 years. If he is going for any professional course, the expenses will increase.
That's reasonable. Whatever fee.
They are not.
Yes.
50,000 ಕೊಡಿ ತಿಂಗಳಿಗೆ ಅವರಿಗೆ. 1,50,000 1/3 we are saying wife and son. Yes, ಅವ್ರಿಗೆ ಕೊಡಿ. Yes, 230.
$74. The TN regret. Is served. $75.
What soon?
Yes.
What soon? Huh? It still survives. EBS corpus after 5 years, 4 years.
It survived.
Huh? What has, whether it survives?
He's not. He's not. Not raised. This is virtually treated as a PIL. As a PIL.
But this says no, can be disposed of on next date of hearing 20/12/2018. He submits that police officer often periodically. 20th December 2018.
What was the age of the missing boy here? Minor. Minor. What happened to the writ petition 85 of 2018? It's a connected writ petition. That is dealing. It was stop or pending.
White charge sheet. Very soon.
Report, not charge sheet.
Is it charge sheet?
In this case, no charge sheet is filed, no? C report.
C report.
The C report is filed, and it is, if the complainant disagrees, we can approach the jurisdiction of magistrate. When was the C report filed? Complaint was what? 4/4/2018. Is one more to be.
Mentioned of first on 28/6/2017.
Status report date.
It is 10 May 2018.
It is corpus petition. Registered pursuant to a complaint dated 6/2017. By petitioner, that his minor son Alakkan alias Suraj from 22/6/2017. So to such a complaint, jurisdictional police have registered a file number 11/2017. And investigation was in progress. Right. Pursuant to the various orders passed by this court. Status report with regard to the persons has been filed. the respondents. And plus in the cases registered with regard to missing complaints. Also placed before periodical. Bernard SAGT. Appearing on behalf of the respondent submits them. So to the case registered in crime number 114 of 2014. Mediation was carried out. And a C report was filed in 2018 before the jurisdictional magistrate. The minor son of the petitioner could not be traced. After filing of the C report also, was any effort made? The pending before this court for the last 4 years. And C report has been filed by the investigating agency. Investigating officer for holding the investigation. That remains that the minor son of the petitioner has not yet been traced. Circumstances of the considered group. There is that no purpose will be served keeping the petition pending before accordingly because of this petition into the to detail the C report filed by the respondent for the jurisdictional magistrate in a manner known to law.
What is the date of marriage? Have a date.
The marriage took place at
Living separately since 5/5/14.
5/5/2014. They are living separately.
What is the cruelty?
The petition was made. The meeting on 28/2017. On the ground of this desertion only in the petition 13(1)(1) small b. But the prayer for on the assumption that you are fluent because that was in that.
No, when was the petition filed? 28 to
2017.
which paragraph of the petition have you made? And ever petition ever meant about that living separately since 5/5/14. Which paragraph? Where? Which paragraph they are living?
In paragraph.
Which paragraph? Paragraph 6. That's what we are asking.
Yes.
Difficult question, right?
Paragraph 6.
He answered it on your behalf. I was going through. It's not a difficult question, right? There has to be a pleading, so we are asking you. And then we will ask you the next question: why the family court has not relied, has this thing, you must have said so. In which paragraph you have said that? No, para 6, where your evidence were said. Then few months of marriage opinion, living separately, para 3, PW1. Right. So why it has been done? I got it.
Okay, the respondent did not pay anything.
The desertion proceeded on the ground of cruelty. All right.
Respondents.
Okay. Yes.
Other end,
Wife's appeal. So what I mean, the marriage has been dissolved. Ground on the ground.
But the degree was passed. There is no permanent alimony award in your before there's some before an application. Master murder in 2021 of 58,000 calls by the respondent. Prior to that, not past some 26.5. January 2022 that we get this general arrears. If I had an application for release of 50,000 which came to be allowed by the court. Release of 50,000 in pursuance of the order to the bank account of the
That has been done, right?
that has been passed.
Yeah.
One more application. That regards the application that I have filed is dated 29th September 2022.
Find out why it is not transferred. Huh?
The dispute is only with regard to alimony. Now you will be satisfied if alimony is given.
What is he doing? How much? You have a daughter? 22 years. What's your this thing? Expectation of permanent? What is your offer? Huh? What? Why?
You can get instructions from them. Only with regard to alimony, you say that you have instructions to argue only on with regard to alimony. I will not ask them what is their expectation.
What is his salary? A, assessed to income tax. Nothing, no instruction. Then what are you arguing about? I'm telling us. Yes, so you file them in both the parties. Assets and liabilities state. Yes, madam. In view of law laid down by this appeal has been filed against judgment and decree dated so and so passed by the family court, by which marriage between the parties has been dissolved by a decree of divorce. This appeal has been filed by the wife against judgment by which marriage between the parties has been dissolved by a decree of divorce. Learned counsel for the parties submit that the dispute in this appeal pertains only to quantum of permanent alimony. Full stop. In view quantum of permanent alimony in view of law laid down by Supreme Court in so and so versus so and so, parties are directed to file their statement, file an affidavit with regard to assets and liabilities. List in the next.
Which date?
29th October. 29th October.
Both of you
what
file.
you have to do, madam?
At least have you followed what is the order passed?
Order. What are you supposed to do by next date of hearing? Senior is out of station.
By the next date, you have to file a assets and liability affidavit of your party.
Explain it to her. She doesn't understand.
Tell your senior.
Which law? Which decision of Supreme Court? Tell her. So who has to transfer?
This morning before registrar judicial.
When was the order passed?
What order shows, office shows that. We will find out why it has not been transferred. We'll find out.
No, there is no order to deposit it in a bank. The order is to release. They will issue a DD for which you have to go to the KJ, that accounts branch. Have you approached there? You are required to file a voucher there. Have you filed it? Have you filed a voucher? Mr. After the order, you are required to file a voucher. Please find out the procedure. You are not even aware of the procedure.
Very good, Mr. Ask the judge what to do. The judge will answer. They go this, go to accounts branch, file a. This is strange.
You find the procedure.
Don't ask the judge what to do. Very good. I mean, had we known that this is a facilities available, we would have never become judges. That you ask judge everything. That our money is deposited in my name. What should I do? The judge will tell you. You go there, go to accounts branch, file a. What is this? Find out. If you don't know, find out. Ask anybody. I inquire. That's better. Yes. Huh? We don't know. The order has been passed. It is passed over.
Huh?
Added further after 2 weeks. Tell him after.
It is adjourned by 2 weeks. Order sheet is order sheet sign agide ante.
Order sheet has been signed. No, Mr. Not fair. Not fair. Not fair. What is it, madam? Well, we are coming back. It's not that we are going away forever. Court is not. What is this? I mean, 135. Why should you? I mean, what? After all, we know that you want an adjournment. What else? Let adjourn. Which case you want adjournment? When? 58 is what has been done, Mr. What? I mean, you don't want to argue. '58 is final disposal. Who the counsel for appellant didn't appear. Sir, we don't appreciate this, madam. Unfair on your part. For your convenience, you will hold the court back just for your convenience, so that you are not required to come here at 2:30. We have accommodated you. Whatever adjourn. Yes. Fine. So we should now. Learned counsel for respondent praise for adjournment list after 3 weeks. Which case? Adjournment. No. Please. Why? What? You want to argue right away? Fine. Yes. Yes, madam, please argue. The present means we don't want to meet. We have not called him. Present means what? What is it? I mean, yes. Wants means you should also want, right? Not that adjournment for 4 weeks. Mediation has been done. So, no. So, is it, I mean, this thing, it is heard by some bench. We will send it there.
Want it to be referred to the mediation center now.
Counsel for parties jointly submit that there is a possibility of amicable settlement of dispute between the parties. They undertake to appear before the mediation center. List on. The parties are directed to appear before the Bangalore Mediation Center on 28/10/2022 at 3:30 p.m. 3 p.m. 3 p.m. Yeah. Discuss. No. No, file as many as this is the joke we are doing. No, this is the joke. Like it will be dismissed for default. You will file an application for restoration. In that application also you will not appear. And the court at one point you will tell the court, I will file another application. It's all open. That it's for you only. Counsels like you only. File another application and 2 more applications. But we will impose definitely costs on you, which you will realize.
Shota.
7-0. It also not dismiss. Revise only. Revise. Make them file an application for restoration. None had appeared on behalf of the appellant on 13/10/2022. None has appeared on behalf of the appellant, even though the matter has been called in second round, line below. It appears that the appellant is not interested in prosecuting the appeal. The same is accordingly dismissed from.
And rejecting her petition and marriage is taking place on 2nd December 2004, and there is a male child born to wait of 17. Respondent has filed a petition for divorce in 2009 in Mysore. Thereafter, on the ground of desertion and cruelty. The petitioner was in the appellant was in Bangalore. He has filed for transfer of that petition to Bangalore.
Desertion and cruelty. What happened?
Now, on the ground of desertion, in 2009.
24/6/2009.
R13. He also admits that the appellant want to during that time and she was there with him. So, for desertion, it has to be a continuous desertion for 2 years.
We are remarried. Release my. Been remarried. Have you remarried?
Not remarried. Don't want to take another chance. Huh?
Yes.
Suffered. Already suffered. Huh? Oh, 56 years. Yes, madam. What is exhibit P7 to P12? You told us no something photographs.
That is R7.
R7 to R13. What? So when these photographs have been taken, how do we find out?
There is a chance. Most people for the last 10 years, they are staying separately. Chances is not there.
Not possible.
Only for alimony means.
So, madam, since how long you have been living away from your husband? No. How long you have been living away? Say 11, 12 years now. 12, 13 years. No, we are something else. Now, is it, even if we set aside the decree, is it possible for you to live with him?
Actually, every week, she has taken in 2019,
No, but what about this statement 2009? 19 you came to Bangalore and this thing, she took you to doctor and all that. You may need your her company, right? That is the age where you need the company of a spouse, not when you are young. You told us 56 years of age, right? Perhaps this is the time where you need the company of your wife, the person who can take care of you. Not ready.
No. She has brought it. She has taken it. Was visiting us. That is what I'm minding.
What is your client? What is your client?
Now she is ready. Just ready to.
Hey, that is what is written. She's saying something else. Have you got instructions on this or you don't know? Council is saying something else, right? Chances of settlement. So we had granted the time to you. Same thing. What have you found out? 13/10/2022, a week's time was granted to you. What is it? He's an assistant. You are a professor, assistant professor, government college. What's your salary, Mr. Salary? UGC skill. So you have a son and the wife to support. In any case, Mr., you will have to pay alimony to your wife, even if you don't want to stay. Not accepted. He is saying that you don't want Alimony, that's what is.
She's saying that was in the 2014. That was in the 2014 now.
Ah. Wow. Hey, Mr. What happens in 5,000 rupees? Huh? What's the age of the son? Then 17 years. 17 years now. Then
what have you paid, Mr. Ready to pay for the last 17 years? What have you paid? 5,000 rupees. And that also she says you have not paid. Ready to pay is not not your readiness. If you are ready, you should have asked her what is the expenses she is incurring for the son's education. Ready to pay, Mr. He is already completing his studies. Ready to pay. That is not the ready to pay means you should, as a bona fide father, you should have asked him what is the expenses you are incurring.
your salary must be about 2 lakhs, right? UGC scale means. What instruction, Mr. 13? I mean, so matter is listed, you will seek adjournment. How long will this 1310, this court has granted instruction? What is it? Why? What? No, if you have not, if you don't know, he will suffer. What is there? You cannot, Mr. run away with your liability to maintain your wife and your son. You cannot run away. Huh? Whatever it is, Mr. You have to maintain with available resources your wife and your son. Therefore, you should need. You should have demanded maintenance from her, right? That's what you are saying. She is getting lakhs of. Therefore, I should be given maintenance. This is the next sentence. Nothing, Mr. Madam, how much permanent alimony you expect? What is such? That's not, he is opted. So for like every this thing we ask something, you seek adjournment, right? Every day, like this has happened, all this that you told us.
When you seek instructions, you have to seek instructions on all aspects. It cannot be part by part.
It's like tomorrow, next date, something else may occur to us. We will again ask, then you will say, no, I will, then I may be granted time. And you behave as if your client is residing in Antarctica and you can't time in contact. Where a post office is required to be opened and there is no access to internet. It's Mysore only, right? What does it take in Bangalore? Then what is it? What time in what instruction? We don't understand.
They are now separated for the last so many years.
No point. You just tell us. We are waiting. Go and tell us. Your client is not traceable, so fine.
He's also in Bangalore only.
Ah. Ah. You paid 25 lakhs permanent element. We will confirm the decree. 25 lakhs you pay. There is no instruction. I mean, this is an order we are telling you. What instruction? You find out.
That's all right. You had given an offer. Therefore, your client is ready. At that time he was ready. Just find out now.
How find out? How many cases, Mr.? How many left? 2 minutes. 3 minutes. 3.
This matter we have.
Ah, yes, Mr. What happened? Huh?
Hmm. 40. 45.
Yes. 45 lakhs permanent element. Huh?
No, 45 lakhs, he said. No, it cannot be like that if the court says.
Installment. First December. And then 1st December. 3 checks. 15. So you can file a joint memo, right? Huh? Please file.
File a joint memo.
Just now, we will do it. Just, fine. No, but he's joint memo. It can be signed by both of you, Mr.
No. Your client has to sign because he is paying.
Only 1 case left. 2 more. Tomorrow, what is the position? Find out how many cases you have to read and how much for us. Default cases will disappear. We are having 75, it will be reduced. I think 50. Not more than that. Have to concentrate on family hearing.
When 13, 14 matters are there.
Yes. These would have been there, he would have kept us busy.
Yes. Yeah, as many as 5 to 6 have taken time in his name. I doubt whether they have engaged him. Or only taking his name.
Two more cases, right? You should call the other case. The other side is not there. There. What is it, Mr.? Your client. On what ground? So not true. He also on the. You should be happy. No. Huh? With 15 lakhs. So what do you do? What's your client doing? 15 lakhs is a reasonable amount.
Wife has filed an Wife has filed an appeal. Why wife has filed an appeal?
Enhancement. Enhancement. So it should be 25, right? No. What's your income? Income per month? Income. What's your salary? When? 2014, right? It can safely be assumed that now it must be 1.25. Maybe no. So, you have any children from marriage? No. Any child born out of the wedlock? No. 6 months. That's my any standard is reasonable, more than reasonable. It's happening 1.25 lakhs. Supposing 50,000 is of 40,000 he gives. So it's better not to. Now there are no chances of living together, right? So then it's only a distinct question of permanent element. She had paid for 50 lakhs. Petitioner is working in a software company, handsome salary. Petitioner is getting at that point of time 1,50,000 was said, and said and was not contravened by the petitioner. Read the para 38. 38, 30. No, this is the fact within your knowledge, right? She had said, you should have said, no, not 1,50,000, only 50,000. See, Mr. Para 38 of the judgment. Para 38, internal page 23. That's what the finding is.
Para 38 of the judgment. And it was not contravened by the petitioner. That's what it is observed there.
What is the document to show your salary, Mr.? Why it's what then you what is it? How do you show that this finding is incorrect? Para 38. You are saying there is nothing on record to show your salary. Why should not be believed that it was 1.5 lakhs?
You could have produced your salary certificate. Why have you withheld it? It was not 1,50,000. You could have produced your salary certificate.
So therefore, inference has to be drawn that it was 1,50,000 in 2014.
Law is settled, no application is necessary. That is the judgment. This court has held that application is not necessary. Is she employed? Is she employed? Is she employed?
Working.
She was a player, but she has to leave, no? What?
There has to be an evidence like you cannot say
That would be only as long as she would play. It's not like throughout the life.
throughout the life they can play well. Hey, Mr. White, please appreciate there has to be evidence. You cannot say whatever you feel like, right? This is an appeal. What is the evidence? Where, which event she participated, how much she was paid? How much money she was paid, and all along she cannot continue to play, right? At that time, she was 23 years. Now what time? She must be 35 years. What player? Volleyball player. She was a volleyball player, right? Then what must be her age? 35 now. Maybe.
She is not employed. That remains. Might have done her MBA or any degree, but she is not employed. You have never said anywhere that she is employed and she has got earning. You only say that she was playing. She was not employed. That's it. You as a husband don't want to pay. Why her family will pay?
No, it's not dependent, mister. It's not dependent on that. She is your wife. Irrespective of this divorce, you are liable to pay permanent alimony to her. It's not that it's not my fault. She has left, so therefore she is not entitled to pay. I am not liable to pay. Can you argue like this?
His petition.
No.
His petition under cruelty is dismissed.
Dismissed.
And hers is allowed.
Your petition has been dismissed.
Therefore, she has proved cruelty. Your petition is dismissed. She also filed on the very same ground, on the ground of cruelty. So she has
I
proved
see.
cruelty.
And you have been assaulting her in Arunachal Pradesh and in Bangalore. This is the finding, mister. We are not timing. Read para 34. If you have not read it. This is not. You can pass an order, right? Yes, go ahead, Mr. You have to. This is final hearing, right? Not a question answer session. All right, sit down, relax. We'll take up another case. You argue the case. Oh, yes, what happened? Joint memo. Which case, Mr. Give 73. Ah. 73. Mr. Where is the file? There. Is an appeal filed by you. Why? Maintenance. Marriage has been dissolved, no? On the ground of cruelty. And why have you filed an appeal? All right. It's his petition, right? MFA number 90. You type no problem. Yes, please ask. Of your presence. MFA number 9049 bar 2015 has been filed by the appellant stroke husband being aggrieved by judgment and decree dated 20th August 2015 passed in MC number 2805 bar 2006 insofar as it awards a permanent alimony of rupees
15,000 per month.
15,000
per month.
15,000 per month to the wife
5,000
and rupees 5,000 per month to the son of the parties. Stop. MFA number 8037 bar 2015 has been filed by the wife being aggrieved by the judgment and decree dated 20th August 2015 passed in MC number 2805 bar 2006 insofar as it decreased the decreased the claim of the appellant stroke husband. Insofar as it decreased the claim of husband, not appellant, husband. or dissolution of marriage on the ground of cruelty. Cruelty. Paragraph. We have heard learned counsel for the parties at length. Learned counsel for the parties submit that the parties have amicably settled the dispute out of court and have invited the attention of this court to joint memo which has been signed by them. The aforesaid memo is taken on record. Paragraph. In terms of the compromise arrived at between the parties, the marriage between the parties is dissolved by a decree of divorce. The appellant, stroke husband, the husband, right appellant, the husband shall pay a sum of rupees 45 lakhs by way of permanent alimony in 3 installments to the respondent wife. The aforesaid amount shall be paid by way of 3 checks, in 3 installments by way of checks. Date. Acha, three installments starting from 1/12/2022. The second installment shall be paid to the wife on 1/2/2023, and the third installment shall be paid on 15/4/2023. Right? 3 equal installments, you write, huh? Shall be paid to the wife in 3 equal installments. First installment of rupees 15 lakhs shall be paid on 1/12, second installment of 15 lakhs on 1/2, and third installment of 15 lakhs shall be paid on 15/4/2023. Right? Line below. Huh? It is, yes, it is made clear that in case of default of
The third
installment, yes, third installment shall be
it is 1/5.
1/5/23 instead of 15/4. 1/5/23, right? Yes. In line below, in default of payment of the any of the aforesaid installment, the decree for dissolution of marriage shall stand set aside. Right? Line below, in view of compromise arrived at between the parties, the judgment and decree passed in MC number 2805/2006, dated 20th August 2015, is modified. Line below, in the result, appeal is disposed of. Appeals are disposed of. Appeals are disposed. 73. 73.
We should also appreciate the part played by the advocates.
No, better to buy peace, Mr. In the long run, you will realize that it is better to be out of the court and be at peace. Now at this age. Signature. You sign, Mr. Get his signature. Where is that counsel? 71.
She's there. She's there.
She's come. Yes, madam, what happened?
I'll go through that.
Why? But if your husband sells himself, we don't know. I mean, assets, 5 crore, huh? Don't know. Oh, so what are your instructions? And he's a bankrupt fellow, right? Surviving on oxygen. How did he speak to you on phone if he's suffering from brain stroke? Mister, what is this? All this nonsense. No, we will direct his personal appearance. Let us, a person suffering from brain stroke talks on mobile phone. Whom you are telling? What? Don't be, Mister. We will send him to jail for making, and you also for making incorrect statement. Person suffering from brain stroke can respond on mobile. Did you speak to him right now? Did you speak to him? No. Did you speak to him? Then how a person who has suffered a brain stroke, he will be on ventilator. How he can speak? He moves around and he has lost consciousness so far as this case is concerned, and his wife and child is concerned. Rest everything is all right. He moves around. That is.
Stroke is different and brain stroke is different.
No. That means. What does it mean that he is not the thing?
What is the instruction? What is the instruction you have got now? What is the instruction you have got for settlement? For permanent alimony? You say you draw UGC salary and you offer 5 lakhs permanent alimony. Whatever it is. Now he says about 50.
How much amount he has got on his this thing?
Retirement, VRS retirement.
VRS, how much?
He has received? What is wanted, you don't get it. Now you could have, when it is for permanent settlement, you should have started the instruction. What is the amount he has received at the time of VRS?
This is it, madam. That's what we were telling, that each he ask you a question, you seek adjournment, right? Like now, so we told him what's the salary. He said, I will seek instruction. Now, my lord is asking how much amount he will again time to seek instruction. What is this?
His pension, Mr. At the time of your VRS, you have got all the settlement. What is the amount you have received?
You told us 60,000. Now you are telling us 70,000.
His pension. That is pension.
He told 60,000 initially. What is the amount which he has received? If you take a voluntary retirement, you are paid some amount, right? Now you take instructions, what time would be the sunset time. Find out from that of him what time the sun will set today. Strange, mister. Everything we need to tell you what you should, this thing. No, nothing, no kindly grant. He has suffered a brain stroke. It should be over as soon as possible. Talk to him, tell him, ask him how much and tell him that he is making this statement before the court. And if it is found to be incorrect, he goes to somewhere else for his treatment. Yes, also, they have got good facilities. Tell him. So you ask him what is the amount he has received on this thing, voluntary retirement. Not less than 50 lakhs. More than that. Going away. Why is change?
What would happen if, madam, even if this judgment is set aside, what would happen? Even if this judgment is set aside, what would happen? No. It's all legal aspects. So you and your son will stay separately and he will stay separately. That's it. If she takes some money for the purpose of alimony, at least she can use for her son's education.
But it can't be 5 crores, right? But it can't be 5 crores. It could be something. Say.
Mhm.
4 lakhs per year, government seat. This goes. Even 30 lakhs.
What's the arrears he has to pay now? $25,000.
$50,000. Mr. He has received 50 lakhs, right? 50% is 25 lakhs. You should pay at least 25 lakhs to your wife. Let me tell you. Half of it. It's an order, Mr. You are getting 70,000 rupees as pension, right? Initially said 60, then 70, then 67.
Yes, we will take it as 67,000 only. That should be sufficient for your
Sufficient,
monthly.
you are a patient. Nothing, you don't need anything.
You got this, out of 50 lakhs, you have got a 25 lakhs with you, and per month you are
67,000.
67 lakhs. You are owning a house. You have your own house.
Say that he is 50 lakhs. No. Maybe you should not take it.
Slightly,
The opponent is the family is we got one man is and one.
You don't know about your wife's family. So she should also. It should also settle in US, right? Yes. Hey, who will take care of your son, mister?
You.
What?
Now the landlord is ordered to pay 5,000. Can be tenant for
Wife also. Yes. No, you are in arrears. 25,000 rupees.
You were supposed to pay that. Also, you have not.
Where is the son studying? Where is the son studying? Bangalore.
You just talk to your client, right?
The amount what you are paying, 5,000 rupees, it will not be even be sufficient for tuition fees.
And wife should survive on the own. You don't have any liability.
What about
And what
wife?
about wife? How can you get away like I'm only responsible? What happens to the wife? So therefore she should support you.
Even
I don't. What sort of?
that is in challenge. That is in challenge. If you people don't want to settle it, then we will hear it on merits. You are only giving you an option. You should be knowing the strength of your case. You are a professor drawing UGC and 25 lakh salary, 25 lakhs is nothing for you. What about the earning for the last so many years he has been drawing UGC salary? What should happen to the money? You have not taken care of your wife and child. And now you have also received another 50 lakhs. You don't want to pay 25 lakhs. You're a professor and you have got only one son. You should have been bothered about his future also. He says that he is preparing for NEET examinations.
So you owe a duty to be reasonable to the court, right? You are an officer of the court also.
Not to the court, at least to the family.
Family.
Reasonable amount, then you leave it to us, we will decide. A professor who is drawing UGC salary and he is saying that 25 lakhs of permanent alimony is too much.
Just now an executive in India has paid 45 lakhs.
1,25,000 was his salary.
He filed a joint memo saying that I will give the amount in 3. That could happen only because the counsel was reasonable. You are just trying to say what he says. He doesn't want to pay anything. He wants to be in arrears. Doesn't want to pay anything. What is this? You don't have any responsibility towards your wife. Then you should tell him that you are telling him whatever is nothing. Oh, I challenge it. If it's higher amount, do whatever.
We are passing order in this.
We'll record the statement. Yes, madam. So please argue on merits, right? It's not possible now, whatever you are saying. He wants to go to Delhi to see the capital in winter. His client. So what to do? Yes, go ahead. Whatever is, we will decide it. We don't know what is it. Yes. So what photographs, and how do we decide? What photographs? So that son can be with the father. So we read the. He is examined as PW1. One six.
I taken the respondent and the child to the class. I took the respondent and the child to KMS to and when the respondent and the child visited me during the February and April 2009. Now I think four photographs who were taken during that. These photographs 7 are 8. Taken in my phone during that visit, and these are marked as R11. When we joint photograph of the respondent are taken during their visit. To mark as exhibit R4. Witness volunteers and present to taken passport during their visit. I have taken the respondent and the child to the wife. Now I see taken at that time. All this has happened in April 2009 and in June 2009.
Yeah, but where does he admit that you have been residing with him till April 2009?
2007, 2008 also she has visited because he has asked her to he changed his house without intimating her, and he told us that you take all your things and go, otherwise I'll keep it in a garage. Thereafter he has changed his house and kept these things in his friend's garage, and at that on 6th was supposed to collect that from that place. So he creates a situation where she doesn't have a choice but to collect the items. And the court said from 6th January 2008, she has voluntarily taken all the items gone. Which she has already stated in her examination in chief also, that she did not have the intention of separating from him. In even as per the examination in chief, paragraph 30 of in chief, I may be permitted to read at page 10 of the that is the wife's examination in chief. So that without the consent of the patient, never got my parents' house. I further submit that I have never stayed. Only when I conceived due to excessive vomiting, I had to stay with my parents for some time. I submit that due to repeated arguments by the petitioner, my health was affected due to me tired. I was not able to take care. I submitted I told him that I would be back in the 3rd week of January. As I needed rest, which the petitioner had agreed. I submit that no help was rendered by the petitioner with regard to looking after the child. Then the petitioner even agreed and told me that he would be visiting Mumbai to attend a seminar sometime in January 2007. So I even told him that I shall come back to Mysore after his return from Mumbai. But after coming back from Mumbai, after a few days, when I was getting ready to go back to Mysore, the petitioner sent a message to my brother stating that something was wrong with me, and if I was sent back to Mysore, and if at all something went wrong, then he should not be blamed for it. My family members were really confused because I had never told my family anything about his weird behavior towards me and the child. It is only then I revealed everything that happened between us to my parents and other family members. But till date, the petitioner has never come to see me. So he creates a situation that he doesn't take back. And then he says that she has joined him, and she has been visiting him. Because she has to go to here to my, she has been in 2007. And that is also admitted. And she has been trying to convince him. Even now also, after he has fallen unconscious, she has gone and they have brought him here. So, let me say that I can file an affidavit to that effect also, that she has taken care of him. So he is making blatantly false. And till now, if he then there is no, so according to me, he has not the desertion. And the court has erroneously said that he has the desertion guidelines. Why that she has voluntarily left his company. And the court holds that on, that is the 6/1/2008, respondent came along with her brother and took all her belongings, and the respondent had joined law. On 6/1/2008, respondent has offered the law and taken all her belongings. He tells her, you leave everything and go. She doesn't have it. So he has taken her, well, because he says that you don't come back. So he cannot say that you don't come back and then Ali is I have. It's like taking advantage of from. And that has been completed by the court by Alimony on the ground of Mediation. Thereafter, at para 20, it is on the order I'm reading. According to the respondent, in the month of April, together. Once again, in the year, they announced are they to invite the brother married. In fact, not in I submit that April 2007 I had stayed with him. I want of saving my marriage. This is in April 2007. Thereafter, when he has shifted his house and he's in the garage on 6th January, he has quite some items from that his garage. Thereafter, the respondent, the wife has made a statement that they have had physical relation during her stay in April 2009, and the respondent has denied it. It is only a word against her. The court has accepted stand saying that it's more believable and to accept the evidence of and she has visited your lordship. Kindly see exhibit R7 from R7. The photographs are produced to the child. Thereafter, the court has said that because the respondent has got the child admitted and she certainly took the decision to have the education of the son in Bangalore after she left the matrimonial home. Now, regarding that, of the evidence of RW1, she has mentioned that she wanted the at page 23 of the respondent's cross-examination, I may be permitted to read. My son was admitted to LKG for Tunbridge School, Infantry Road, Bangalore. Since then, my son is studying in Bangalore. I have made efforts to admit my son to my school, but my husband did not give consent. But the court holds that I have unilaterally taken the decision to admit the child to a school in Bangalore. Thereafter, the court holds that thereafter, in the order, thereafter she joined her father's school and is working as head mistress. She had no courtesy to inform her husband or take his consent about pursuing higher education and getting an employment. Now, regarding this, there is no proof or evidence for the court to come to that case. Neither of the parties have made any statement regarding that. Thereafter, the respondent had made a statement that prior to the marriage, the appellant had made a statement that prior to the marriage, the respondent had demanded site or house in Mysore. Now, regarding that, at the 18th of the order, the court holds that according to the respondent, because of father refused the house in Mysore. This happened prior to the marriage, and that is what she is seeking in the process. The court holds that that is the reason for her to live separately. Her contention is that he has not allowed her to join. Thereafter, the petitioner denies this fact. The respondent has not examined her father, substantiate her contention that has married and her parents had demanded to stay. Further, the respondent has not initiated a criminal case against the petitioner and his parents for alleged demand of site or house harassment meted out to her by the petitioner and his parents. Now, instead of that, all who were standing that her purpose is to save the marriage and not find any criminal case against and the cross-examination at page 18. She has been cross-examined on this. I did not lodge any complaint against my husband having assaulted me under the influence of alcohol. Volunteering that I do not want to break only because my husband did not get transferred to Bangalore, I am the false allegation. Now, all through her contention is that even prior to the marriage, he said he wanted to get a transfer to Bangalore. She said that we will still separate if you want to get a transfer to Bangalore. Father's house. She was not agreeable. And she was ready to join him in Mysore, but he has not permitted her to join. And regarding the suggestion that there were breaks, petitioner himself has ended that he at page 16 of the para 4 of the cross examination. Earlier, I used to smoke and I consume alcohol. Thereafter, the court holds that it is relevant to note that during her stay in the matrimonial home, or after she left the matrimonial home, the respondent has not lodged any police complaint against the petitioner about misbehavior, abuse, or cruelty inflicted on her in the drunken state. The absence of any positive proof of contention of the respondent in the petitioner abuse her physically and verbally in drunken state and attempted to throw her out from the matrimonial home cannot be accepted. So only because she has not filed a complaint, her basic case is that she wants to join in that. If she files a criminal case, then automatically it will be taken that at one side you want to join the husband and on the other side you are filing criminal case. Thereafter, the court has at page 31. The court has said that after she left the matrimonial,
See, continuation of the it appears to be court. Yes.
Regarding the filing of restitution, there is a statement now my question is that I think 2009 Mysore. Thereafter, he paid answer. 16 April, we got the order for transfer. Thereafter, notices were issued. We have appeared mediation has taken place in 2011. After she came to, she was that he was not ready to take her back. Thereafter, he has filed the petition for restitution for conjugal rights because she had hoped that that has also been done, that he has delayed filing the restitution petition. Because she has not gone to the court, genuinely hoping that he will allow her to join him. Thereafter, the petition, the husband has, after this entire process is over, he has filed an application for recalling and producing document saying that Exhibit P4, which according to her, him is a suicide note. Now that is a diary of the respondent, of the wife, and the entire diary is not produced. Only one has been produced. In what circumstance that was written, he has explained that there is no date on that. That when she was pregnant, and at that time, she has written in the diary. I request the parents, and this is my last time. Was pregnant in that state, why she has written that because of the delivery fear that something may happen to her, she has written this note. Now, without there is nothing specifically mentioned that he wants to commit suicide or anything. But the court considers this as a suicide note and holds that he has threatened him that the wife will commit suicide. And further, if he would have produced the entire diary, because that would have given the sequence events on what basis she has written this.
Where is that
But he doesn't produce them.
Where is that explanation?
Pardon?
Where is that explanation which you
Regarding
that this one suicide note?
yes,
You said
in the
where?
And further, they have not referred to these documents in their pleadings anywhere. It is directly come only in the evidence. In the cross-examination of the So these documents have been produced by the respondent after the examination of the wife was over. Thereafter, they have recalled and produced these. And in the further the cross-examination of the husband, page 20. It is true to suggest that exhibit 5, P4 is the page of the reading, were not referred to in my affidavit evidence. I have obtained exhibit P response diary. It is true to suggest that I have not produced the entire diary. It is not true to suggest that after the respondent has conceived, she was suffering from early pregnancy sickness and she became very weak at that time. It is not true to suggest that during her pregnancy, an apprehension that something wrong may happen to her during the delivery, the respondent wrote exhibit P4. It is true to suggest that in exhibit P4, it is not particularly stated that respondent is planning to commit suicide or to attempt or commit suicide. It is not true to suggest that intentionally I have torn single page and produced it before the court. Witness volunteers that except this note, exhibit P4, the entire diary was empty. It is not true to suggest that I have no obstacle to produce the entire diary. It is not true to suggest that I have been making a statement that the entire diary is empty except exhibit P4. It is true to suggest that except exhibit P4, I have not produced any so that respondent has attempted to commit suicide. So these he has directly after recalling after my evidence over, thereafter he has got himself and then the production of these documents was given and that was allowed and he has given. And these additions were made. And the fact that he could have just produced the entire diary because that would have shown what 26 was diary. There was no need for him to tear just one page and produce it. Thereafter, on the ground of cruelty, this is one the court has held that she has tried to attempt suicide. Thereafter, at now para 30, there is the allegation that the respondent is white and assault the petition to many occasions to character. There is no cross-examination. That is what the court has said. But page 15 of the cross-examination of the PW1 para 2. I will just read that. Respondent frequently used to commit suicide, threatened to desert me, and she was not cooking food, abused me physically for 2 to 3 times. These are all the ill treatment committed by the respondent, which I refer to in para 6 of the affidavit evidence. I do not know the date, month, or year on which she attempted to commit suicide. That exhibit P4 also does not bear any date. It is not true to suggest that the respondent never made to commit suicide. I am making a false statement. I have not lodged police complaint against the respondent for having beaten me. I have not produced any documents to show that medical treatment was taken by me. It is not true to suggest that respondent has never beaten me nor attacked me. Therefore, no medical evidence is available with me. I do not remember the exact date on which other of the respondents told it. So the court has stayed to go through the entire evidence of the which has been produced. And it is only on the basis of this exhibit P4 the court holds that however petitioner has satisfactorily proved that the allegation that respondent attempted to commit suicide, threatened to commit suicide, always insists on resign his job at Mysore and come and stay with the parents' house in Bangalore, threatened to file false dowry harassment case against the husband-in-law, put them behind bars to suspect the character of husband, which are grave as cause of cruelty. Now, even the dowry harassment, if she wanted, she would have filed. The very fact that she has not filed any case which is admitted by the husband also, that except the restitution of conjugal rights case, there is no other case filed by the wife. And it is on these grounds the court has erroneously held that the husband has proved desertion as well as cruelty. And from a reading of all these documents and the evidence, it is clear that the court has not gone through all the evidence which was produced and the cross-examination. And therefore, I pray that my appeal may be allowed and the order of divorce will be set aside. And the petition for restitution of individual rights.
What about permanent eligible? Nothing.
No, I had not.
All.
However, the fact that the couple had a special relationship at the point of time is highly imputed. The fact that the 6 months late, the respondent to all including the girl and greater remains admitted. Being so, the respondent will be matrimonial law and not according to the it is intended to part of the interest and the point of time, the physical is highly unbelievable. In this regard, we will to take the to for the and also for the admission of the school, the father signature is required. That is why we went there and only on the list of the time when the child will be through and other parents and they are not any physical contact with children. Therefore, my honor the visiting of the appellant by to the restaurant husband's houses only to take the signature of the for the passport and also for the full admission for them. I think the article is really good. First of all, my suggestion is that kindly the husband has kindly divorce to be done in the year of 2008. Then the notice has been issued to the appellant. He has appealed to the court at Mysore for 21, and thereafter the summons has been served on the is very well the husband is in the divorce before the family process. And that petition has been transferred to Mysore in the year of 2010, and the real number of 3,000 the family process ends. When she has the knowledge with regard to the divorce petition, she has not even included legal notice or any petition in 2011. For the petition, now we made the petition the current and the legal rights. The private column will be where both private and another please to pass the judgment in degree. Of restitution of funds, there will be responded to done. So, not the really directly husband to try the respondent to live in matrimonial law. He has not start for the directly the husband accepting the husband to accept the woman. This trial is not done. Which is let the company of the in either of 2006 and 2006 and thereafter on 6/1/2008 as the mention is clearly applicable on 6/1/2008 he along with receipt from the job and the receipt to the member. That is when he reviewed because he is looking after these those who are deciding in respect. The respect is a real message. Design the document. And there are the method. In the year 2011, he has made the extension of Finalizing. And since 2006 method, till today, he is residing in Bangalore. And the residing in Mexico and the investment. When he was working in Mexico, now, deciding in investment. Yeah. Because today, the Desertion is coming in. The airport has clearly observed with regard to the Desertion. On the other hand, the respondent consented the marriage itself not related to in the sense of the allegations made in the legality in para number 4, the petition submit that the time of marriage itself, the respondent created this scene by saying that the rules were not proper to the rules very good country, not very good country. Even during the marriage, the respondent and the relative behave very rudely and parents and brother. The behavior is the same in many relations regarding had demanded that the petitioner to give them a safe measure. The petitioner father had refused to give the safe and it was not so if a safe was not given and typically meant the responsibility he would behave rudely to the petitioner in the military thought of the petitioner. It is also responding to us visibly to one of the last grade. He told me that if at all in the future he wanted to develop with the wife, he would approach it. The petition would in fact the lawyer and are making the statement on the wedding day. The friend even told that the respondent that it is not even 1 hour since the marriage has taken place and it was not the respondent, his behavior will be very peculiar. He would suddenly get into a range of create a scene. He has even responded to the he would behavior giving in Bangalore. Petitioner has tolerated all their the hands of the respondent. We hope that things between them will improve and they will be able to live happily and thereafter. This allegation is made by the respondent that he is rude and creating the behavior was very peculiar. He made that allegation against the husband. How he is now ready to leave the husband? It is highly impossible. He has made several allegations against the husband. His peculiar behavior, he is more loss of welcome. When she knows the all this husband, and also has made several allegations regarding the husband. Now it is after the restriction. The husband has made an allegation against the husband. His behavior is different and well behaved. How he can go and join with the Taking was even now also it is not possible because it is after the lapse of 16 years, they are living separate. Separate. It is only if the heart to heart is accepted, then they can lead the marriage. Possibly cannot possibly sentence Desertion. It's not thereafter, he completed BA and she ran the working day. She is working on the day when she came to Bangalore, and here she is working. If she came to visiting the husband in without any other fun. What purpose is it? The husband has clearly stated citizen. She used to come to parents' house, staying in the Bangalore. He has also said, if you house, immediately parents of the suffering, in spite of depression association, to the safeguard to show the matrimonial life was not broken in the society. This petition has been affected with the fund. Easy mind entity. And husband is very this group is responding, but manually we do not know always we are not any way. In her document also, she has stated the communicate, he did not pay her. He would not want We are both legal parents. Out of them, we are one reason. It's only legal. Other is the elders in the many agrees with the PhD, PhD, ID, MSc, PhD. The younger brother is graduate. My father is studying school. My name is school. Students from there is two things like that. Study the others told the children is one of the father. It is not going to be the condition to stay in my husband used to I have asked him before that my husband preferred that. That's the reason the state is making very responsibility. Did not have any complaint, any. This one is. One on the. These are not did not lose the never did and will be did not lose did not lose did not get transferred from visual to regular. I do not remember. The time of filing an application for passport application, I was staying in Bangalore. My husband was staying in Mysore. The night of it, I was next to him. Even the others, he has created and he was he has stated that he also resided in Bangalore.
What does it show? What does it show? Therefore, it shows that she had no intention to separate from him. Whatever it is, there is, because he has filed an application in Bangalore for passport. Therefore, maybe her intention is that they are staying together. That shows that he had no mindset to show that her husband is staying separately from her. He has shown that her husband is staying with her. Take that signature and she has filed an application stating that her husband is also staying along with her in Bangalore. Therefore, it shows that he had no mindset to show that her husband is staying separately from her. What false affidavit is? What is that? What is the falseness in that? No what?
Get the hospital. Yes, ended two facts.
Therefore, her defense that she had no intention to separate from him and she was willing to continue with him appears to be correct. What allegation? You have admitted it. He has made an allegation and you have admitted it. It does not mean that it does not mean that any husband, any wife is not staying with a person who takes alcohol and smokes. You have admitted that you were consuming alcohol and you were a smoker. Then it's not false. What you have said is not false. What allegation? That you are quarreling with her, etc. Yes, that is. That is the reason for her to stay away from you. That is the reason for her to stay away from you. Question is whether you have made out a ground for divorce, whether you have proved desertion and whether you have proved cruelty. It is not that as to how she will live. You have to prove that you have made a ground for desertion as well as cruelty. You are going on reading. What is your argument?
The concept of the
Hey, Mr. Sir, you are going on reading and not make submission. Now, please tell us, when the court has held that the wife had stayed with you in the month of February and April 2009, you have filed a petition in the month of June 2009 on the ground of desertion. When a finding is given that she has stayed with you in your house at Mysore, month of February 2009 and April 2009, where is desertion? The question, I think you have understood the question.
There are 6/2008, she was living in and she took all her belongings. And she has been the Mysore.
Why are you not answering the court question? There is a finding recorded by the court that she has stayed with you in the month of February 2009 and April 2009. When that finding is there, how can you say that there is she has deserted you for 2 years continuously?
No.
Huh? She has stayed with you. She's not taking signature and coming back. She has stayed in your house. Overnight she stayed, and thereafterwards the entire family went to various places. Where is desertion there? You have to prove desertion. You are not. There is a court has given a finding that she has stayed in your house. Therefore, the ground of desertion cannot be there. Continuous desertion should be there. And even she has made a statement that there was a cohabitation between the party. She has said that. And very surprisingly, the court says there could not have been. You might have denied, Mr. You might have denied, but the fact remains that the court has recorded a finding that she has stayed in your house. What purpose? That we don't know what purpose. Nobody can say. The wife has stayed with the husband in your house. For what purpose? Nobody can say. That is wrong. Observation of the court. On what basis he makes that? On what basis? Only for the purpose of signature, why is staying overnight? And why is the question of taking the entire family to various places? Therefore, there was no desertion there. There should be a mindset. When the parties want that the child's interest has to be safeguarded, then there is no desertion there. Yes. Then now come to cruelty. When it comes to cruelty, there is a finding recorded by him that this whatever that suicide note that is written by her, it's a suicide note. And what is the what cross-examination? She has not. You have not cross-examined her on that at all. Just show me. Just show me. Yes. Yes. This was produced after her examination.
Signature only in the state will not be she has written
So she does not dispute that it is her handwriting. It is admitted. Yes, you have seen that. You have seen that. He has said that the child may be given to my parent. Yes. 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 How do you say that? What is the suggestion given to you in cross-examination? He has given a suggestion that was written in a diary when she was pregnant, and with an apprehension that anything can happen at the time of her delivery, she has written that note. That is the suggestion put to you. That is the suggestion in your cross-examination. You have not read it. What can be done? Read your cross-examination. What she has suggested. Your cross-examination on 3/10/2013. Keep this file. We repeated from that. This one. It is not true to suggest that during a pregnancy with an apprehension that something would go wrong may happen to her during delivery. The respondent wrote Exhibit P4. That is the suggestion. That is the suggestion. You might have denied it. That is the suggestion. Therefore, that cannot be, because you admit it is from the diary. That is admitted. And there is no date in that. That is also admitted. She says that she has written it at when she was pregnant. Why should we disbelieve? Yes, suggested. He has not written it. There is no date in that. Therefore, it cannot be said it is a suicide note. On what basis you say that it's a suicide note? There is nothing, and there is no material to show that she has attempted suicide at any point of time. What document? Why you should say why it that suggestion put by her should not be believed, that it was written at the time of her pregnancy and apprehending that she may, something may happen to her, she has written that because I am suffering at the hands of my husband, my child may be given to you. That does not mean that it's a suicide note.
That's all. Okay, thank you.
The grounds the court has wrongly held. That's why we gave you a chance which you did not.
72 and this thing will remain, right? 74, huh? Repeat it. 74.
We gave you an opportunity, not even on once, two times. We told you, we should know you.
No, nothing. No opportunity, you have argued it now.
We gave an
That's
opportunity.
Yeah, nothing.
What after argument?
No. No, this is not fair. Not fair.
We gave an opportunity.
We don't know. We have heard you.
That is left to you whether you are.
Forcibly cannot. We decide the matter on merits. It doesn't mean that you have spent her life in litigation, therefore we should decide contrary to law. That doesn't mean. No, we will record this submission also that you are saying. Very good, very good.
Nothing, no opportunity. This is unfair to the
We
court.
gave you an
Mr.
opportunity.
We gave you an
We gave you
opportunity.
an opportunity. We asked you twice to contact. And your amount 25 lakhs is nothing for you. You are drawing a UGC salary. But 25 lakhs is nothing. That should have been double.
No, nothing. Not
And we told you repeatedly, you were so much unreasonable. 25 lakhs is a big amount for a lecturer who is drawing UGC salary. And you say that if just a few months back he received 50 lakhs as settlement, then what is the small amount 25 lakhs for him? He has earned for so many years and 50 lakhs he has received just 3 months or 4 months back. Anybody would have been readily come forward. You did not do that. He gave you opportunity.
No opportunity. We don't want to set a wrong precedent that after having argued, what opportunity? You have argued the case. Thank you.